If John was beaten up and attacked in that house, who did it?
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know.
Okay, you're aware he was beaten up by Brian and Colin Albert. I mean, we're all in on the same joke, right? My tail light was cracked and John was pulverized.
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
Good morning, everyone. Sorry, I'm a couple minutes late.
Good morning.
Oh, you sound great tonight, this morning, Matt. I'm gonna send a link to my friend Boomer. He just comes where I go most of the time. What a morning I had. Just to vent for a minute. The majority of my work now I do at home, which is fine, great, whatever. But I swear to God, my family interprets that as like my work is home. So every morning I have to frantically go around and pick up behind them. And my kids, one's an adult and the other one's not far behind. So this shouldn't be this way, but it is. All right, rant over.
So who do you think we have today?
I don't know. Yeah, we're starting with just a completely new witness, no cross or anything lagging over from yesterday. I'm not sure. I wonder if they're going to have more state troopers maybe.
Yeah, that's what I'm thinking. Or, I mean, because they do have additional medics. I mean, maybe they'll save the best one for last. Like maybe Flamati will be last because they started with Nuttall and then Flamati is one that they really couldn't attack on anything. So maybe it's like putting the ones that they're going to attack in the middle and put the strong ones at the beginning and the end.
Yeah, that's possible. I wish that we could just fast forward to Aperture. That's really what I'm interested in. Is there?
I know, and the defense witnesses, because I know it's going to be a comedy show. Do they have someone that's going to say it wasn't hypothermia? Like, I just can't wait for that.
Yeah, that to me was a shocking twist when they said that in opening. Like, I don't know why you went there.
It's weird.
Wasn't his body temperature something like 80 degrees, 80.1, something like that?
Which is extreme hypothermia. So
right. Yeah.
And it's like, they never detected a heartbeat. Karen said that she pulled glass out of his face and it was gushing blood, but Carrie was the one that was brushing the snow off his. It's like so weird. Like, what are they thinking? Is this Karen's idea?
I think she's driving the bus mainly. Yeah.
I do too. Like yesterday when she called, he was done with that witness and she called AJ over to ask another question. His face was so red, he didn't want to ask it. Right. And the question was, she wanted him to repeat that you asked them to take a picture. And I think she's wrong. Like AJ didn't want to remind the jury that, it was still on the truck when he asked after he found the first piece. But Karen is thinking, oh, because they didn't take a picture, let's point that out. So she is running the show because he looked pissed. Like he didn't want to ask that. He didn't want to reiterate it because it does point out that he called to get a picture and it was still in the truck, which means it wasn't in the Sally Port. I mean, I think it was in the. I mean, I don't know, but.
No, I think they started the search pretty much as it was pulling into the Sally Port.
Right.
There's no time there. I mean, I think that was established well in the first trial. I think it's established in the second. There's no time to plant evidence.
Yeah, and I mean, I think that's her whole case because if a jury is just looking at reasonable doubt, it's like, maybe he got out of the car and slipped and fell and cracked his head open, right? But the fact that her taillight is there, those marks on his arm, and that's why they're so desperate to say that those are dog bites, even though your average person is like, yeah, sure. And to say that her car crashed in the driveway, which, I mean, I just think it's, unless they can get one juror hung up on some of this other nonsense, she's guilty. Like, she's going to be convicted.
Yeah, I'm 100% certain she will not be acquitted ever, right? Can't do it. Too much evidence. The question, the variable really here is whether or not it's another hung jury because they really have polluted the jury pool. But hopefully not this time. Hopefully they really vetted these jurors well and they take their oath seriously.
Yeah, I mean, I think, ARCA kind of put some question in their minds maybe last trial, but the jurors didn't really seem to think anything much of them. So it's
Right.
like, I think it's just, we didn't have like a very clear accident reconstruction the first time. I think that was the main thing. But everything else that they came out and said was kind of like, well, the hypothermia did it. She didn't do it. But it's like, so I think that they just need to, I don't know, the medical examiner is a little weak, but I think that's normal in cases. The medical examiners don't want to commit to anything. Like anything's possible. You ask them what's possible, they'll say, yes, anything's possible. But that's only when you're looking at one injury in a vacuum. Altogether, there's not many things possible.
Right.
Wasn't attacked by a rabid dog after getting his head cracked open with the glass next to him from the bar that he had when he got out of Karen Reed's car. Like, I mean,
Right.
the glass shows that he didn't get too far. Like, I mean, that's what that shows to me is like he got out of the car with the glass and that's as far as he got.
Right. His phone shows he didn't get that far either because his phone's right under his body and it doesn't move. Yes, Marie, I will set up a poll in a minute. I think that maybe she should just go full Lori Daybell at this point, just represent herself.
Yeah, that would be. She'd probably love going at these witnesses.
Yeah, she would. Yeah, she would. So no, Alicia, I mean, if she's convicted, then it's up to the judge. I know if she's convicted on the second-degree murder, it's a minimum mandatory sentence of 5 years in state prison. Yeah, so I don't think she'll be getting 16 months no matter what. I think at this point, she's pretty much going for broke. She could face life in prison. I don't necessarily think that's going to happen, if I'm being completely honest, but it is a possibility.
Yeah, I mean, if they charge her with intimidating the witnesses after this, then it's a possibility for sure.
Yeah. No, if they are able to indict her on what she has clearly done with this conspiracy, each one of those counts carries a maximum sentence of 20 years in prison, and there's a lot of victims in that. So yeah, that could be her dying in jail, prison.
I mean, I think her clips and the evidence and the testimony like paints a very clear picture that he got out of the car, went down in that spot, and then somehow she knew exactly where he was. And I think that they just need to show the accident reconstruction. I think at this point, like that's not really a question, is that, he stopped moving that spot, but why, right? And so once the accident reconstruction comes in, right, I don't think there's anything else missing from the prosecution's case, really. She was in a rage.
She was drunk. She was angry. She found him expecting to see him in that condition in that spot because it's where she last left him. Her words, not mine. She says that what she thinks could have happened is pretty much exactly what the state believes did happen. What are the odds? Like, yeah, she's really screwed the pooch on talking so much. I noticed that now she's quiet after court. It's a little bit too late, though, I think.
The arm. I mean, I think the arm is what's going to tie that to the taillight. If they have matched it up. I mean, I've used it. I didn't do exact measurements to scale, but like there's a lot of patterns from the taillight that match what's on his arm. There's like a right angle, which is clearly not a tooth. It's like a square. Like it came from something mechanical, and I think they're going to be able to match it up to the taillight. And if you think about the initial impact, would have like the marks around his elbow, and then as his body's thrown, those will be like the lateral lines. And I think that's pretty easy to explain. They didn't explain it in the first trial, so.
Right, but I mean, I think that part of that was unfortunately Trooper Paul's issue. Not that he was like. I think his science was solid. I think that his report was solid, but he got so rattled by Jackson so quickly that Jackson was just throwing stuff out like, oh, so he flew 30 feet in the air and did a pirouette, and Trooper Paul was so rattled and nervous and confused. He was just like agreeing with him, even though his report doesn't agree with that. I think that Alan Jackson at some point could have been like, and then Malaysia Flight 370 came down and hit him right there. And Trooper Paul would have been like, yeah, that's what I think happened. Because he just, it was too much for him testifying, I think.
Yeah, Jackson has that way about him.
Plus the TV cameras, the small courtroom, knowing what's coming with the harassment, because it's like all of these people getting on the stand for the Commonwealth, know somebody else who has had to testify or is involved in this case. So it's like, or goes on social media. So it's no secret that you're going to get harassed, right? Like there's no secret that as you're testifying, people are sitting on Twitter or Facebook or whatever else, writing nasty stuff about you and looking up your wife and kids and whatever else. So I imagine that a combination of all that, TV camera, small courtroom, high stakes, Jackson's badgering, the possibility of harassment, the unknown of what's going on, what's being said about you by, millions of people, probably all converges and creates a very uncomfortable situation to testify, more so than usual.
Yeah, for sure. I have to drop off for a few minutes, but I will be back
That's
on.
fine. I'll be holding it down. We'll talk to the chat while we wait. Toby says the Commonwealth still has to clean up the impact time, though that might be tough with witness memories being flawed in past testimony. I can see that, but I think that there's always going to be like how many murder convictions do they have like an exact time of death? Like down to the second. I don't think that there are many. I think, obviously Adam Lally misspoke with 1245. That kind of got thrown out there at last trial. This time it seems to be pretty pinpoint down to like 1231. I'm surprised at how precise they've been able to be, but I don't know that you necessarily need like the exact time of death. I think that as long as everything kind of fits, it's like a jigsaw puzzle is the way that I look at it, really. Are all the pieces fitting? And I feel like so far all the pieces fit pretty well. Yeah, we're not going to tap into Grant's feed. Grant will go nuts and demand attribution and start throwing even more watermarks on things. We don't need to get into the weeds with that. Yeah, I appreciate the Karen cam, but I don't need it. I don't really care that much about her facial expressions. I care more about the testimony. That's just me personally, Yeah. Good morning. Yeah, they are using PowerPoints heavily this time, Good Egg, which I think is great. Anytime that you can have like a visual aid to show people, like I said, I'm really interested to see what Aperture does, just because it's going to be, and no disrespect to Trooper Paul. I think Trooper Paul is a smart guy. I think Trooper Paul did a good report. I think Trooper Paul knows what happened. And I think that his math and data was probably pretty solid without having seen it. That being said, he just wasn't good at testifying. And you've got now this Judd Welcher guy from Aperture, and he's I believe he's the vice president, but he's pretty high ranking in that company. So I'm going to go out on a limb and assume that he's had some experience testifying before. So I think it's going to be a completely different ball game. And I think that's really what the prosecution needs more than anything else, is just that real clear presentation to explain, like, this is how we know it's a car, collision. And I think that everything else just kind of fits, like, again, like that jigsaw puzzle just kind of fits together and really shows the picture of what happened. I should do the poll, so hold on. Bear with me. Sometimes it echoes because I have to actually go over to Kevin's YouTube to start the poll. So if you hear my stupid voice echoing for a second, that's why. But I do think that the strongest case here is, there we go. The strongest case here really is that OUI manslaughter. And like, again, I understand why people think murder. I understand that technically she's probably guilty of murder, but you're even hearing words getting thrown around in testimony now, like accident. And I think that's probably where it's going to land personally. But, you know, I'm not a lawyer and I'm often wrong about things. So who knows? All right. So I'm going to put up this poll. Guilty. Yes, eyes on heaven. I know backing up a car is intentional. I'm not saying like, I think that I have two different opinions as far as like what I believe she's actually guilty of is I understand the law, and then what I project a jury will land on. And so I totally understand that by the letter of the law in Massachusetts for second-degree murder, like I believe that the government has surpassed their burden for that, you know, as far as that that negligence prong, and definitely the failure to render aid afterwards. I think that it's pretty clear that she knew well before 6:04 a.m. that she had hit him and that he was lying there in trouble. I don't think that it's a tough reach to make to get there, just based on her statements and her behavior in the morning alone. I really like when I look at like, I hit him. Oh my God, did I hit him? You know, knowing exactly where he is, expecting him to be there, the franticness. I take that as her knowing what had happened. And so therefore, whether it's 2 hours, 3 hours, or the whole 6 hours between when she left him and when she came back with Jen and Kerry, at any point she could have called for aid, and that may have saved his life, right? So definitely intentional to back up her car at that rate of speed. Insanely reckless. Anyone should know that doing that when someone's behind your car carries a substantial likelihood of seriously bodily injury or death. I believe that she knew at some point, and that she, you know, didn't call for help. So murder too, I think it's there. I just would not be surprised, and I'm leaning towards thinking that a jury might land on manslaughter, just because, you know, again, I don't think she intended to kill him. I think that, you know, she was just insanely selfish and reckless, and kind of callous about the whole thing. But I don't think she backed up her car thinking, I'm going to kill this guy. And I think that might be a distinction that the juries might land on. That's just what I think. It's just what I think. Yeah, I know there's been a lot of talk about DV. Now, I said from the beginning, honestly, that I recognize this as a DV homicide, because as I'm sure a lot of people are aware, you know, leaving a DV relationship is often the most dangerous time. And when I look at the messages and the communications and hear the descriptions of just sort of surface level stuff, and we'll never know what happened behind closed doors, right? You just never know. Some of the most normal looking couples, behind closed doors, there can be domestic violence. But I look at the way that she would use manipulation, controlling, jealousy. Those are all hallmarks of an abusive relationship. And it certainly does not have to be physical abuse. And it always runs the risk of escalating to something like this. So I thought from the beginning that this was a domestic violence homicide, and that may be a tough pill for people to swallow, you know, at large, because I don't think that a lot of people think about men being the victim of domestic violence, but they certainly can, and certainly are at times.
So I'm told counsel wants to see me as the jury's coming over. Why don't you come up to sidebar?
Oh, Lord. Every morning. I agree, Janet, that there'll probably be a strong argument for second degree during closing arguments. And I think Brennan really laid it up in opening by explaining the distinction there and some of the elements of the crime. So yeah, again, I think personally that the Commonwealth has met their burden on that, but I can definitely see that being a sticking point in jury deliberations, just because she doesn't look like a murderer. We do profile defendants. That's an absolute fact, unfortunately, and she does not fit the profile. So that softens her up a little bit for the jury. Her behavior in the morning was obviously frantic, but arguably remorseful as well. Particularly, Officer Sharap's testimony. If you believe him, I do, that she was saying things like, "Oh my God, this is all my fault." That's remorse, right? That's not somebody who intended to kill a guy, and was happy that he was dead and wanted to get away with it. I think that she was just angry and reckless and, unable to handle the situation once she had hit him appropriately, like a normal person. And that is murder too, but I can see why that would be a sticking point. No, Gina, she's not a high class Eileen Wuornos. I don't think she takes any pleasure in killing. I don't think that she's somebody who you let her out and she's immediately going to go kill again. I think that she runs a risk to the public in the sense, though, that if a situation like this were to arise again, how she's going to handle it, and it's going to probably result in the loss of human life, because she is not mature enough and put together enough to understand that if somebody gets seriously injured, or you think they may be seriously injured, that you call 911. You don't call them a million times leaving abusive messages hoping that one will garner a reaction and they'll answer and you can absolve yourself of the worry. And you certainly don't, take 5 hours to think about what you're going to do, call your parents, call everybody, grab some witnesses, and then come back to find somebody dead. No, Cookie, I agree. She realized that she hit him. I believe that she realized that she hit him. I believe her behavior from that moment on strongly suggests that she knew that something had happened. But again, I don't think that it was necessarily with the intent to kill him or possibly even hit him at all. Matt and Jen described these kind of squiggled tire tracks in the snow. So it's entirely possible that she backed up too fast, kind of lost control a little bit and clipped him, again, the onus is still on her at that point, though, to call for help. And I mean, it's particularly negligent because not only, like, there were people awake in the house, and she knew that because that's where they were going. So if she really didn't want to be the one to call 911 for whatever reason, she absolutely could have run to the house, knocked on the door, flagged somebody from the door, and gotten them out there and had them call for help. This whole thing with Brian Albert was a first responder, coming out of the house, blah, blah, blah. Yeah. After Karen hit him, I'm sure if she had gone in and gotten Brian Albert, he could have been pretty helpful. I'm sure Brian Higgins, who has before saved a man's life, by the way, in the course of his duties at his job, he probably could have been pretty helpful. There were things that Karen could have done in those moments that could have saved this guy's life, and she didn't. But I don't necessarily think that's cold-blooded murder in the way that we would think about Eileen Wuornos or Ted Bundy or Jeffrey Dahmer, or somebody who kills for pleasure, or even somebody who kills for insurance money or out of extreme jealousy. It's not. I don't think it was that with her. I think that this is just gross criminal negligence. And I know no matter what, as far as the civil case goes, wrap that up, it's done. She's going to be held responsible because of this gross criminal level of negligence and the lower bar for civil. But I think that I would not be shocked if this lands at manslaughter. We don't know who's coming in today. It's a surprise. It's a secret. Yeah, no, leaving someone to die. I'm not defending Karen Reed. I guess this is where I'm most reasonable. Kevin's always reasonable, and I'm obviously very strongly opinionated and can get rather partisan. I do not like Karen Reed. However, where I get kind of nuanced and try to be a little bit fair is that life is not so black and white. You're not either good or evil. She's not either a cold-blooded murderer or completely innocent of everything she's been accused of. These things can be nuanced. And I think that she was distraught and upset in the morning. I think it was genuine. I think that was the most genuine that she's been this whole time, is in those first moments, right? Where she is expressing concern. Oh my God, is he dead? I'm sure she already knew the answer, but I don't think she wanted that answer. This is all my fault. I hit him. Admitting it, it's a certain level of remorse in that indicates that at some point she was, I think, genuinely distraught. It just quickly turned out that she cares more about herself than the person that she killed, but is that a hallmark of a good person? No. Does it make her completely abject evil? Also, no. The manslaughter, I think, is a maximum sentence of 20 years. I'm going to assume that whatever she's sentenced is probably going to be in the higher range of these recommended sentences because of everything, right? And I think that some of this extra stuff with the media campaigns and the witness harassment, that'll probably be brought up by the prosecution for sentencing to kind of enhance that, some factors that are not necessarily going to mitigate her exposure. And we know in the Turtle Boy case that his consistent, re-victimization of his victims over and over and over again, the prosecutors already said in open court he intends to use that at sentencing if that gets that far too. So, she took a bad situation and just made it 10 times worse. And that's obviously how I read the message from Matt McCabe. If she pleads, this is over. And if not, this is going to be an episode, because, she's certainly made it into to an episode. Yeah, the state's murder two laws, it's essentially, it's very close to manslaughter. It's very close to manslaughter.
You are unmuted.
I think that the volume might be a little bit low on my end. We'll see. Let me know if the volume is okay, guys. If not, I can switch streams over. I'm on Court TV right now.
Okay, thank you.
Not disagreeing with you, anti-war care. I am confident in saying that she's a bad person, but evil is a very, that's a term, man. That's a strong word. That is definitely a strong word, evil. I try to reserve it. Exactly, Infoman. She's bad, but also troubled. Compassion is a difficult exercise. I think the internet makes it more difficult, but I would argue that sometimes the most unlikable people are the toughest ones to offer any compassion to, but it's better for you to try than it is them even. I've even said at some points there, I feel bad for Turtle Boy on some things, right? Just I don't know if I would call it empathy or compassion, but at least a little sympathy. That one's a tough one for me, but gotta push yourself a little bit. We're losing a lot. The internet is doing a lot to us as individuals, as a society, I think, and unfortunately, I think compassion, empathy, sympathy, all that is quickly going by the wayside. We shouldn't let that happen. That's how things like this happen. I'm not pontificating, by the way, because like full disclosure, this is stuff that I struggle with too. This is more my internal monologue a lot of the time, I guess, that I just kind of vomit out behind the screen. But I have to remind myself, and therefore I'm reminding others in the process, that you want to at least try to be a better person today than you were yesterday. Try to give a little bit of compassion, even if the other person doesn't deserve it. But I don't think Karen Reed's a good person at all. Like, I would not hang out with her ever. Ever. I don't consider her to be a good person. Like, I will not feel bad if she lands in prison at all. Maybe a little compassion for her, because it sucks. But I mean, if anyone deserves it, it's Karen. Bossy Texas Chick, I do not think Turtle Boy is evil. I think he's a bad person. I think he's a malicious person. I think that he should be stopped. Certainly I think some of the things he does are but I don't think he's inherently evil. Like, I don't think that he would carve up a baby or anything like that, or kill for pleasure or anything that I would consider to be truly evil. I just think that he's a textbook narcissist he does take pleasure in emotionally harming other people for no reason. But no, I don't think he's evil. I really, really, really try to reserve evil there are things in this world that I think are evil, but less people so much as, ideas. I try to remember that hurt people too. And I try to remember that I'm not perfect and I've done some pretty shitty things in my life, and usually not in a good place when I'm doing them, So I try to remember that.
Judge, while we're waiting for the jurors, just for the record, I think Ms. Little had an opportunity to review the redacted exhibits from yesterday, and I don't think there was any objection to them.
That's correct. All right, thank you.
Would all rise, jurors enter.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, holding indebtum within and for the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
All right, good morning again, counsel. Good morning. Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. All right, Mr. Brennan, your next witness, please.
Thank you, Your Honor. The Commonwealth calls Connor Keefe.
Come on, sir, follow me. Step up, raise your right hand. Face the clerk, thank you.
You raise your right hand. You solemnly swear the evidence given to the court and jury in the case now and hearing should be truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Good morning.
Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure. My name is Connor Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes.
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the academy.
How long was the academy?
Approximately 6 months.
Did you have any further training after the academy?
On the job training?
Yes.
Yes. In various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the District Attorney's Office.
Did you have a role in investigating this case?
Yes.
Were you a assigned investigator in this case?
I wasn't the main investigator, but I was involved, yes.
Did you deal with any of the digital forensic evidence?
Yes.
Specifically, regarding the digital forensic evidence, did you meet anybody to obtain a phone?
Yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes.
Is that different than analyzing the phone?
Yes.
Were you involved in analyzing Kerry Roberts' phone?
No.
Were you involved in analyzing Jennifer McCabe's phone?
No.
Was your role limited to attaching it to grade key and doing the extraction?
That is correct.
And did you do that?
Yes.
In addition to the phone extractions, if you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes.
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag.
And why would you do that?
To secure it.
How would you become aware if there was a piece of evidence found?
The CERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a bag, evidence bag.
Do you know if those photographs were time-stamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with Exhibit 74, please. Trooper, do you recognize that item?
Yes.
What is it?
That is a black Nike shoe.
Did you see that item that night?
Yes.
74A, please. 74B. Thank you. Is that the same sneaker?
Yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Do you have gloves?
Yes, sir.
Do you want the lights on, Mr. Brennan?
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please. With the court's permission, I'm going to move this piece of evidence, item into evidence. Let me ask you a few questions before you open it. Could you stand and show that bag? There's red tape on it. What's that for?
To secure the bag closed.
If the bag is open, is it then retaped?
Yes.
Do you write on the outside of the bag?
Yes.
Why do you do that?
To memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir. Sorry.
With the court's permission, can he show the item?
Yes.
Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag, I'd ask this to be marked as an exhibit.
All right, any objections, Dean Eddy?
There is no objection.
Exhibit 77.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who is collecting it.
The time that you write on the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that could be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
I'd like to move now to Exhibit 75, please. And preferably 75A, please. Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A, please. Do you recognize that item?
Yes.
Is that an item that you bagged that night?
Yes.
Do you have both of those items with you?
Yes, sir.
Could you produce those, please? Ms. Gilman, you could take that down, please. Thank you. 570.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury. Sir, on those items that are stickers, did you put the stickers on them?
I did not.
Do you know where the stickers come from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just 2 pieces or is there another piece in that bag?
There's another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off, or do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well? Is that smaller piece consistent with the same color as the 2 bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please. I'd move this into evidence, please.
Okay.
We're back on another sidebar. Over nothing. So I can answer that. The 47 pieces is like, piece is almost a subjective word in this context, because you've got like, you look at her taillight and a piece is missing and it's one large piece, but then that piece can shatter into infinite pieces.
So, Mr. Brennan, I leave it to you and the witness how you do that part.
Yes. Sir, in the small chip piece, you don't know how it became chipped?
I do not.
I'd ask you to remove that chip. Like you to safely secure it, bring with you, and bag it when you leave.
Yes, sir.
And I'd like to introduce that exhibit.
78.
So we're going to mark the little chip.
You want-
Ms.
you'd like to mark
Giannetti
it?
asked to
Okay.
mark that. Yes.
And we're going to submit that for identification. So the small chip that I
Madam
asked you to
Clerk.
secure.
Madam Court Reporter has an envelope for that.
Thank you very much.
Exhibit 78.
Thank you.
Exhibit BB for identification.
Thank you. Trooper, we have one more bag of items to go through.
Yes.
Could I have exhibit 73, please? Sir, if you could look at exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
I'm showing you a photo. You recognize what's in it?
Yes.
What's in it?
The piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as an exhibit, please.
Okay. There's no objection, Ms. Giannetti?
There's no objection, no.
Exhibit 79.
With the court's permission, could we show Exhibit 79 to the jury?
Yes.
Ms. Gilman, would you be able to close? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please? Are these different in color than the last pieces you showed?
Yes.
With the court's permission, could the trooper show these pieces?
Yes.
Thank you, trooper. I'd move these items in evidence.
No objection, Your Honor.
All right.
Exhibit 80.
Thank you.
Thank you, Trooper Keefe.
Thank you, sir.
All right, any questions, Ms. Giannetti?
Please, Your Honor, thank you. Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Kerry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself?
Yes.
In this case, it would have been an iPhone 11.
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number.
The International Mobile Equipment Identifier.
Okay. And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form,
Yes.
and the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well?
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022?
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
May I approach, Your Honor?
Yes.
Now, I just ask you to read that silently and then look up at me when you're done, Trooper. Having reviewed that form, does that refresh your memory as to whether you indicated a date and time?
I did, yes.
And what was the date and time that you indicated?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct. 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay. So don't put it up on the.
I will not.
Exhibit 81.
Now, Trooper Keefe, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay, it's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not a homicide investigation. No,
You have not yet.
no.
The lead investigator is the trooper who is responsible for the case, correct?
Yes,
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
yes.
If somebody asked within your unit while this case was going on, whose case is it or who has that case, your answer would have been Michael Proctor, correct?
Yes,
The two of you have worked cases together in the past, correct?
a few.
You've worked on this case with Michael Proctor, correct?
Yes,
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
you'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
If I may just have a moment, Your Honor.
Okay.
Okay, Trooper, you do not remember interviewing Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes,
Okay. If you saw a copy of that report, would that refresh your memory?
to an extent.
May I approach, Your Honor?
Yes.
No, not at all.
Yeah. I've placed a document in front of you. I would just ask you to read that silently to yourself. Look up at me when you're done. And Trooper Keefe, just so we're clear, I'm not going to ask you any questions about the specifics of what Sarah Levinson said, so you don't have to brush up on that.
I'd just like to refresh. Take
Sure,
a look, sir.
go ahead. Having reviewed that report, does that refresh your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
yes,
Okay. And the two of you would have participated in that interview together, correct?
yes,
But you did not write the report, correct?
no, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report, correct?
I did not have any input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind. Let me approach Judge.
Yes.
Thank you. You're welcome. Other examples are the reports on the videos that you, well, strike that. Let me start by saying this. Asking you this. You retrieved videos from both the Waterfall Bar and Grill and CF McCarthy's, did you not?
That's correct.
You and Sergeant Buchanan retrieved the videos from CF McCarthy's, correct?
Yes,
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure. If I may approach?
Okay.
Oh, I'm sorry. And again, if you read that silently to yourself and look up at me when you're done. Okay. Having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. I
Right.
did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes,
And that, by the way, I said waterfall. Is that C.F. McCarthy's there, or is that waterfall?
this is C.F. McCarthy's.
Okay, I meant C.F. McCarthy's. He was the one to review that video, correct?
Yes, again, I only got a copy of the surveillance video.
Sure.
I did not do any
And
analysis.
with regard to the waterfall bar and grill, that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes,
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
yes, I would have to see that report as well, sir.
Now, another member of your unit was Trooper David DeChico, correct?
Yes,
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
So there you go. They've cracked the case. They've uncovered a nickname.
Trooper, in terms of the troopers that were in your unit as of January 29th of 2022, which members of the unit had the least amount of time in the unit at that time?
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes,
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
he could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John O'Keefe on January 31st of
I did.
2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes,
That was done at the medical examiner's office
the medical examiner's office in Sandwich, Massachusetts.
in Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes,
Had you met her prior to that day?
no,
Had you spoken to her prior to that day?
no,
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
With regard to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
Mrs. Staines, you can ask that differently.
What, if any, conversations did you have with Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
there was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes,
You also learned that there was a small cut above his right eye, correct?
Yes.
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment. May I approach, Your Honor?
You want this one back?
Oh, please, thank you. So I've placed another document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done. And I would direct your attention to the second page for the question I just asked you. Having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one?
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives Unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Objection.
You knew when you left that Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
You knew when you left that in your presence, Dr. Scorti-Bello had seen the injuries to John O'Keefe's arm.
Object to the line of question.
Sustained.
May we approach?
Okay. Jurors, feel free to stand up.
Yeah, he's trying to really start us seeding or sowing some seeds as far as the injuries not matching up to a car accident. I don't think this is the witness to do that with, but here we are.
were you watching Dr. Scortibello as she was conducting the autopsy?
Yes.
Did she appear to be looking at John O'Keefe's body?
It's the same thing, just ask the different.
What direction were her eyes facing when she was examining John O'Keefe's body?
I don't recall.
Okay. Was she looking at the ceiling, Trooper?
She was doing her job conducting the autopsy.
And in order to do that,
the body.
I'm sorry?
She was looking at the body, I assume.
Thank you. And looking at the body, you saw her looking at the body, correct?
Yes.
And looking at the body included an arm, correct?
Yes.
And it was at the arm was not covered up during the autopsy, correct?
No.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
I don't recall.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
And it is common practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there, correct?
Yes.
And there was nothing that prevented you from giving input to the doctor as she examined the body, correct?
We don't give input. We give the facts that we know so far in the case.
Okay. Well, giving the facts is giving input, is it not?
It's not input.
Okay. Did you talk to Dr. Scortibello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input, correct?
Yes.
And at the end of it, you left without her ruling it a homicide, correct?
Objection.
I have nothing further.
No, none, thank you.
All right, you're all set, Trooper.
Thank you.
So, jurors, this break we're going to take now. All right, we're going to take a break. The lawyers and I have some work that we have to do, so it's a little bit longer break than we normally take, and it's a little bit earlier, but we did get coffee for you, so we'll take a recess now for the next half hour, maybe. I want counsel to stay.
All right, for the court, please. Close your notebook, follow me. Seated.
So I want to talk a little bit more about what we talked about at Sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get quickly the evidentiary basis. This is straightforward judicial notice there are two separate decisions which require two separate.
One's a Massachusetts case, so that's easy enough.
Okay, so, and that's a shall.
It's an SJC case, so yes.
Yes, okay. So now to the Maryland case. So that's governed by federal, Massachusetts Rule 39A, and that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course, a court is a judicial proceedings of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
CC for ID.
Okay, thank you.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor. And the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what.
In one area, right? One specific area?
Well, you can call it.
The decision.
Right. Oh, yeah, just what's in the decision, but there's two parts to that decision, two areas. It's FLH, frequent location history.
Right.
But what the court also got at was Apple source codes, that she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
So what is it so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking me to allow.
If I could give you the answer, Your Honor, I will explain it. It's a very short answer.
Okay.
What I want to do is with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp. She is not using Apple's source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is in fact what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked about that, then what?
Oh, if she's not asked about the 227, I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. This here, number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance to materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location. And although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it was. The 227 timestamp.
No, that was raised, but this, what was problematic in Maryland, the same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been Daubertized with regard to Apple source codes. And if I could, Your Honor.
Okay.
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the state Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on. So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got Daubertized on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them in this case. It's just basic cross-examination.
You can see the plan to dehumanize somebody, Daubertized, to use a term to suggest some type of conclusion that has no basis in fact is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue. By their analysis, if an expert goes into court on a motion on anything to do with data forensics and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic data analysis at another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data steps. So there are certainly aspects directly relevant. Here's the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision, how do you impeach an expert? That one of the fundamental ways you do it is, and I don't mean to dehumanize her, I won't even use the term Galbraitize anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. You and any expert that's been deemed that, you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. But I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court. And one part is the location she has in her PowerPoint she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp for 227 is not related to the search. They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion from a court that she's an unreliable expert. And this is how they're going to distort it. Invoking the Constitution and invoking the client's rights has nothing to do with the analysis. That is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion. It wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it is a totally different related report, different related item. It's as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in. In another court, in another jurisdiction, they would not be able to be cross-examined that in some court, there was an opinion they offered that was deemed inadmissible, unless they were talking about the very same methodology and the very same point. This has nothing to do with her opinion whatsoever. It's just an attempt to try to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a different judge and distorting the fact that it's two different methodologies, it's two different issues.
One last word. Go ahead.
Thank you, Your Honor. He just said credibility. This isn't a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion
And this is the equivalent of a Superior Court opinion, right? It's not an appellate
It is, Your
decision.
Honor. It is, Your Honor. It is the equivalent. I respectfully don't think that the level of the court is at all relevant. Any court, unless you get it overturned on appeal, then this would be a different matter. But this is a valid case, and even if it wasn't, it shall be in evidence. So there's two issues here, and I think the Commonwealth is conflating that. The question first for the court is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says ipso facto, yes, as long as I've got a certified copy. So it is in evidence. I don't know why we're perseverating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her. The final sentence, the decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about Ms. Hyde. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology with regard to her PowerPoint. You heard Mr. Brennan's answer. He has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, she has no peer-reviewed article to say that how she is determining that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't, in anticipatory, have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become evidently clear that it's a proper basis for cross-examination.
All right, and Mr. Lessie, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
Your answer, Your Honor, my answer is I would be entitled, but I would say this: if they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls. But if I could avoid talking about 227, I would, but it is necessary for the basis of her opinion. There's just no way around it. And again, this is something that after a defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was a offer of proof earlier on similar evidence, but not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds.
Okay, but then answer my question after your 10 seconds.
But I will. Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision, and it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. now to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue. Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's.
Yeah. And Your Honor, my point would be that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are putting at issue the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the right, respectfully, to cross-examine on the issue that they're putting in issue, and they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here.
Your Honor, may I ask one thing? May I, Mr. President?
I just want to know, is she here?
She is, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
I do not think that Alessi is a good attorney. This is ridiculous. Absolutely ridiculous. Ridiculous argument. Admissibility in a court is not reliability. So I'm not sure why we're conflating this at all. It's just desperate. Absolutely desperate. Right. They've had 3 years. This expert is here. This is ridiculous. Ambush. They're just constantly trying to ambush the Commonwealth. Right. This is what it feels like to me. Trial by ambush. It's more confusion. I think Alessi's superpower at this point is annoying this judge. The witness, so they're talking about Jessica Hyde right now. Jessica Hyde is in the courthouse getting ready to testify, and now Alessi has brought up that he would like to attempt to impeach her because in a Daubert hearing in Michigan, they determined that her testimony was not admissible for that case in Michigan. It has nothing to do with this case or Massachusetts or anything at all, really. But here we are, entertaining this bullshit.
Goodbye.
Okay, so it looks like they're taking a recess. Yes, slow roast. You can shower now. Yeah, she needs at least 30 minutes. This is a ridiculous waste of time. Presumably they've known that Hyde was going to testify for a while now. Why they're just bringing this up is beyond me. I agree with the chat. Honestly, I think she's probably going to allow this. I think it's ridiculous. I think that she does tend to capitulate to the defense, though. And on this one, I think it's pretty ridiculous if it does come in. But yeah, I will. Anna, right now we're on a 30-minute break. The judge is considering a motion by the defense to essentially impeach Jessica Hyde, a digital forensics expert for the Commonwealth, on cross because a court in Michigan once refused to admit her testimony in a completely unrelated case in a completely unrelated state. So she has had this sprung on her. The judge has. Jessica Hyde is in the building, presumably set to testify today. And they're on a 30-minute break for that. So it's kind of quiet here right now because I'm alone. And I am watching along with everybody, but also trying to... Maryland. I'm sorry. Thank you, Carly. It's not Michigan. It's Maryland. Maryland. Thank you. Do I stream elsewhere? I have my own channel. I don't really stream on it. I generally, honestly, would not be streaming the trial every day on my own. Last trial, I would jump in with Kevin here and there. But I am doing this because Kevin is very ill and I want to keep his stream running for him until he's able to get well and come back to us. So yeah, I apologize for the low quality commentary at some points. I am not Kevin. And I generally would not be streaming every day. Not really my thing. I like making edited videos a little bit more. I like to write, so. Good morning, Jen.
Hi, how are you? I thought I would jump on and
save me.
Give you a shout and everybody out there. Thank you all so much for supporting all of our channels. And as Kate said, unfortunately, Kevin is really struggling. I actually contacted him. Could we do a meal train? What all can we do? I think everybody on this channel, on all of our channels, we really care about Kevin and want to help. But right now he's just in a situation where he just needs to convalesce and have some time. So anyway.
Yeah, I reached out yesterday as well and said, people really want to help. And I had said, I directed them to your PayPal, not sure, but he doesn't want anything from anyone, number one. And number two, although I understand people wanting to help him with meals and stuff like that, he really can't eat right now, unfortunately. If anyone has any, good ideas on how to handle the acid reflux that comes with chemo, I would love to pass it along because it really does upset me that, he's in so much pain and can't eat. But yeah, I mean, right now we're all just praying for him.
Right. And thank you, Kate, because for everybody, as you all know, it takes a lot of work, just a lot of time. And, Kate has so many other jobs and things she does. She has a family and she has the knowledge that's required to go on and do this for Kevin. So I just wanted to say thank you, Kate. Kate's channel is really entertaining if you guys ever want to take a look at it. And I say that because Kate is a true believer in the First Amendment, which is great. So am I. But I tell you, on her channel, anything goes. So I just have to say, Kate, I admire your channel and your ability to just deal with trolls. I'm less tolerant. I don't suffer fools as well as you do. But I love your engagement with everyone. And the other thing that Kate is masterful at, if you have looked at any of the long shows she's put together, the long clips regarding different subjects in this case, they are nothing short of just completely professional and very well done, where she puts together the facts and lines them all up to make the point. She's got one on Aidan Carney, the blogger. She has some on just what's happened throughout this case. And no one knows this case, I would argue, other than the prosecution and the defense, better than Kate. She lives in and around that community. Kevin lives in and around that community, Matt. And that's why, for me, when thinking about who to sort of team up with just to present this case, I think all these people who know facts, because that's where I live, in the fact world. I really love that they have so often so many of the details and answers that so many don't have. So thank you, Kate. That was my
Thank you. That was really nice of you.
big spiel. Say thank you.
No, I think that definitely being local has helped, and Kevin as well. We both kind of took it upon ourselves to really talk to people in and around that community. I live in a neighboring community, but I'm not actually in Norfolk County. I'm in Bristol County, so right next door. Canton is about 30 minutes from me. So just close enough to kind of hit home, but not so close that I was really plugged in from the beginning. But, I immediately started talking to people in that town, around that town, witnesses, victims, all that, to get a feel for the situation. And then, when Kevin had sort of figured out what was going on and that he had been duped a little bit with the conspiracy, he jumped right in as well and was really, really just would talk to anybody and has talked to a lot of people. So, I mean, I think it's important, if you're going to have an opinion on something this big, to try to immerse yourself as much as possible and understand as much as possible. Like I said, what I miss about Kevin the most with his commentary is that he is a lot better at being unbiased than I am. I have a very strong bias. I do not like Karen Reed. I do not believe in any sort of reasonable doubt. I don't see it. I think the operative word there is reasonable. And I think, especially this time around, the defense, just everything about them is the antithesis of reasonable.
Yes. The thing is, it's hard, I think, for you and I, Kate, because we're so, we've watched every second of the first trial. We've read the motions, from now it's going on 2 years, that we've been embroiled in this case. And so when you have a fact pattern and that has led you to a logical conclusion, it's not about being biased or unbiased. It's about not being able to turn your back on the facts that and and the logical conclusion they lead you to. So I really don't consider people who have followed a fact pattern and have been led to a conclusion bias. And looked at the other fact pattern. In other words, looked at the idea or the notion that John O'Keefe entered a house that not one witness says he entered, that his cell phone says he didn't enter, that the expert said he didn't enter, except for by one point, which he said you needed to use the calculation of all the data points, which show he stayed in and around the fireplace, the fact that there was no snow under the body, and the fact that anyone could logically think that an ATF agent of decades of working for the ATF, a 30-year veteran of the Boston Police Department, a dog, and a minor, which is really their conclusion, for no particular reason during one of their kids' parties, decided to bludgeon this man to death and then, intelligently, tongue in cheek, throw him on the front lawn. And where is the proof? Where's some DNA? Where are the drag marks? Where's the, complete mess that would be made of the home? Where are the discussions about all of this, the cover up that would have to be involved? It's so illogical that for many, it's been impossible to go down that road. It just is. So I wouldn't call it bias. I would call it being logical when you look at facts.
Yeah, I mean, I suppose that the way that I'm going to weigh the facts naturally is always probably going to be in the light best to the Commonwealth in this instance, and I try to be mindful of that. For instance, and this was something that Kevin and we still don't agree to this day, but I was, the 2:27 a.m. search, early on when he was still kind of sorting everything out, we would talk, and I would, of course, I'm very strong in my opinion of like, she did this, and he would always say, but the 2:27 search, if she did in fact do that at 2:27, game over, huge. I never saw that. I didn't. I mean, one Google search for how long to die in the cold, independent of anything else that would, cast suspicion of, doesn't mean anything to me, really. I think people Google strange stuff all the time. I do too. I joke that, my Google searches could probably get me hemmed up, in the right context, but they could. I've probably looked up weird questions. I can't think of anything off the top of my head, but just weird stuff that might be a little bit macabre. Doesn't mean that I murdered anyone. So I never saw it. I never saw it, particularly when you peel back the layers. And I think the biggest problem here, for me anyway, is they can't place him in the house. So he died in that flagpole, and the only question left is how. And I feel like there's enough circumstantial evidence to really butt up as to how, the taillight pieces, the trace evidence on his clothing. And now I think it's stronger and stronger every day, because we've got brilliant Karen Reed making insane statements like, yeah, of course I saw him immediately. I was expecting him to find him there and on the side of the road. And I was feeling so much dread for how I was going to find him. And yeah, he's right where I left him. Like, I feel like it's pretty clear. I feel like I would be almost ready to convict her just based on what's been shown already, which is a bias, right? Because jurors have to listen to both sides.
Well, I think the point is, though, at the end of the prosecution's presentation last year in the first trial, I didn't feel as confident at the end of that as I feel right now, and we're maybe halfway through the prosecution's points, because they're doing I mean, Brennan is doing such a great job. Again, he has the clips to work with, which I've never seen a trial where you put on a prosecution witness and their point is substantiated by the defendant herself. Whether you're talking about whether the taillight's broken and cracked, and she talks about it and picking pieces, throwing it on the ground, or whether you talk about whether she said, I hit him, and then she says, well, of course I said I hit him. I just don't know if it's as many times as they're saying I said it. So it's very interesting this year to watch the presentation. Brennan is great. And don't get me wrong, I thought Lally did a great job under the circumstances. And he's a brilliant man too, and knows this inside and out. Recall too, now the defense has had a long time to prepare, and that's why we're seeing this situation with Hyde. I see some people in the chat asking me my thoughts on this. So I think that this should be able to be discussed in a cross-examination only in as much as the witness should be asked a question like this. Has there ever been a time that you haven't been allowed to testify, or that your testimony was found to be unreliable in any way? And then Hyde should be able to answer that to her ability. That's all that should happen here. There shouldn't be introduction of records, because the case, at least from what I understand, wasn't even on a similar notion in terms of what was collected and what she analyzed. Brennan said it perfectly. And this is why experts have to be really careful to stay in their lane. On the stand, if I'm ever asked about, say, as an example, my medical background, I never purport to be an expert. Yes, I've been a tactical EMT for, since 2000 and, oh my gosh, 3. So a long, long time, and practiced in a lot of situations, and rode on the ambulance and worked in a hospital and all of that. But am I really an expert? No. And I try not to get into that now. If they ask me specifically, and I've had that happen, about what I believe, I will say, I preface it by, yes, I have a lot of experience in this area, but my area of expertise, you really have to have that nailed down, not by you and not by anybody else, but by what a court of law says. So if a court of law has decided you're an expert, that's what really dubs you an expert, right?
Right.
So anyway, was she considered an expert, or did she go a little bit afield from what her expertise is? I don't know. But that, in my opinion, should be what the judge should decide.
Right. Right. I mean, yeah, it just seems to me to be a stretch, like a huge stretch.
Yeah, it came in so late. It's so ambush. I mean, you just cannot trust this defense team. They're just, I don't care what side of this you're on. They've been found in a court of law to have had a lack of candor with the court, which means lying. That's what lack of candor is. That's what we use in government terms in the FBI. We say lack of candor, which just means you're lying. And that's what they've been found. And we just see it over and over again. My point being here is, how long have they been sitting on this information with Hyde? I don't believe whatever they have to say on it. Whether they said, oh, we just came across it, or, they could have had this forever, and we'll never know. But it's back to their techniques. You look at how they've conducted themselves in this trial and last trial, and this is their methodology.
Right. I mean, I feel like at some point she needs to put a kibosh on the ambush, because that seems to be what their modus operandi here, right? Is just to constantly ambush this stuff in last minute filings. I believe ARCA's report is due today. I have not checked the docket to see if it came in. Perhaps I will this afternoon to see what happened there. I mean, I'm going to assume that they're going to get it in, but that's kind of an ambush situation too. I feel like the Commonwealth's probably at least halfway through their case.
Yeah. I wanted to I was looking at chat while you were chatting there, and one of the posts mentioned that the case was decided in March. Yeah, March. That's, almost 2 months ago. That's March, April, we're into May. So again, it's just ambush, in my opinion. I love to see Kevin on here. He's talking away a little bit.
Yeah, I know he's getting ready to go into the hospital. I'm just hoping that he gets well soon. We need Kevin around. We need Kevin in this world. There's not many people like him. I was talking to somebody last night actually just about Kevin's courage, right? He has a lot of it, and that's an important thing to have today, I feel like.
Yes, absolutely. Another question is regarding Alessi, to me, being very unresponsive to the court when he specifically asked whether they are going to call green.
I know. I feel like, I'm trying not to read too much into it, just because I feel like Alessi's argument style, the way that he interacts with the court, he seems to just be naturally kind of evasive. Am I wrong? I feel like he has a very hard time directly answering questions.
It's actually very interesting with him. He's the only one, I think, that routinely Judge Cannone says, listen, we're limiting it to 10 seconds. Listen,
right.
I need you to be brief, because Alessi, and even when she does that, he talks for 3 minutes, something he could say in one sentence. His style is almost to just have verbal diarrhea, where you're just inundated with words and not even sure what he gets out. And I think that is truly his style. I mean, purposefully.
He definitely is quite verbose, but I also find him to be evasive, like directly evasive. He'll go, oh, I'm going to answer that question, and then veer off somewhere completely different. And then, we're left with like, okay, but you still haven't answered the question, bud. Green, he almost made it seem like they had more than one digital forensic expert at their disposal. I don't recall seeing any other names of digital forensic experts that I could recognize anyway on their witness list. So I'm a little confused by that, but I could see them really weighing whether or not to even call Richard Green, because this 227 search is pretty dead. And Richard Green is going to he's going to get eviscerated if they put him on the stand. Hank Brennan is going to tear him to bits. I don't think it's going to help at all, and it could potentially hurt.
Yeah, it'll be interesting to see. I've said that about him, and then I've also said that about the dog bite expert. I think that both of them are really looking to step into a lot of trouble. And I've said it about ARCA too, because now everything comes in, and we've seen the judge say, I expect a very rigorous cross, basically saying I'm opening the door for all the misleading ARCA did on the stand.
Right.
And I think that is going to be very interesting.
Right.
Yeah, Kara, Dr. Russell is exactly who I'm talking about. I think there'll be all sorts of trouble on that cross for the defense if they call her up. And they have another dog bite expert now anyway, that the judge said she's going to let a lot of what this trainer has to say in, which I'm very surprised.
I was surprised by that as well. I don't find him to be qualified. I think that he could be a little problematic for the Commonwealth in theory, because I believe that he will know how to speak to the jury, and he will probably come off pretty likable and believable. He has a huge YouTube channel, huge social media presence in general, so he is definitely used to public speaking, and is younger and obviously more charismatic than some of the other witnesses they have. So, I mean, at the end of the day, it's all junk. There's no way that you're going to get bit by a dog and magically have no DNA. That's really not reasonable or logical. But, you know, this defense knows how to razzle and dazzle them. That's for sure. So I think that Garrett Wing is actually a concern. For now, I would be curious if they just replace Dr. Marie Russell with Garrett Wing altogether. I don't think that they can, because I think he really can't speak to causation, can he?
You know, he can't. He has no medical background. I've kind of joked about this before. My sister and my stepmother for years have trained German Shepherds. Still have German Shepherds. They're dog trainers ever since my sister's probably started training when she was 7, 8 years old in 4-H and showing and everything. That does not make you a dog bite expert. That's where I talked about some of these experts get into areas that I think they can get in a lot of trouble with, so I agree with you. It needs to have somebody with a background that could discuss causation.
I mean, Garrett Wing essentially has the same qualifications as former trooper Leah Janduso. Anyone who is familiar with the Turtle Boy lore would recognize that name. But just like Garrett Wing, she was a state trooper. She was a canine officer. I know he was a canine officer for a police department. And then she left for different reasons than Garrett Wing left his career, granted, and became a dog trainer. So she does the, detection, bite protection dog training, all that. Same qualifications as this guy, pretty much. And I would absolutely trust asking Leah questions about training dogs. Less comfortable about asking her how to treat dog bites. And it's such an odd thing too, because most of the time people do not need to ever identify dog bites, not knowing what they are. If somebody gets bitten by a dog, then they come in identifying, or somebody witnessed it, or it's abundantly obvious. This is a unique case for them. I think they really are trying to take advantage of that. It's almost like proving a negative.
Yeah, and some things you can just, in this particular case, some of those photos have been so adulterated. I always post that original photo just of the arm, and you can see this isn't, the coloring is not like they post where it's these deep red, horrible gashes, and you can see the bruising. Everybody keeps saying, "Oh, there was no bruising." Oh, there's bruising there, all right. And where's the lower jaw? The fact that Dr. Russell changed her mind multiple times, whether it was scratches, whether it was biting, whether it was both. Some of the things she said were mind-boggling. I can't believe they will put her on, but they may have to. But Hyde should come on, and Hyde should be able to answer. And I think they'll put Green on just for Alessi to spin a million questions and just leave the jury going, huh, was there a point made there?
Oh my gosh. If Alessi, directing the direct examination with Richard Green, that is literally like, you could use that for interrogation in Guantanamo Bay. Like, I can think of no higher form of torture watching that man conduct direct examination of Green. Holy crap. I can't stand listening to Alessi. I feel like this must be how the Free Karen Reed people felt about Lally. I didn't feel that way about Lally. I know that he was a little bit dry, but he was all right. But Alessi is just like, not only is he boring, but he's like needlessly argumentative and just needlessly convoluted in the way that he speaks, the way that he questions. It's torture. And of course, Richard Green, I think, is a buffoon. So.
My husband, just in passing, right? This poor guy has to be subjected to listening to this and listening to me talk about this ad nauseum. And this morning he walked by and he said, "Who's that guy? He's so annoying." He just happened to pass through as I had it on in the background. And I just thought it was so funny because my husband's the type that he pegs everything. He's like, just calls it the way it is. And he's so on point with what ends up being what most people think or believe. And so I always run everything on, by him. What do you think of this? And he'll either say, Jen, nah, I wouldn't go with that, or yes, and he's typically right on point. Yes, Rose, we love Lally. Poor Lally,
Yeah.
He's being upstaged right now, but quite frankly, he had 5 different hats on, and clearly Brennan just has such a easy way to listen to. What does somebody say? Oh, wow, he's easy on the eyes. I just think he has this great way to ask questions, and he's engaging. And Lally is more like a Lessie from the less than engaging category.
I think he's been doing really well on his direct with the experts, though. I think that in some ways he's able to, especially with expert witnesses, he's able to elicit a little bit more in a more streamlined, dispassionate way. I do feel like, obviously, Hank Brennan he's more of a performer for sure. He's definitely more engaging. But, I've always said I appreciate a dispassionate prosecutor, because I believe that that's what all prosecutions should be at their core. Just unemotional, not personal, dispassionate. We're just trying to get to the truth here. We're just trying to administer justice. It should be a duty. Administering justice should be a duty. It shouldn't be a performance. It shouldn't be a pleasure. It should be a duty, right? And one that is done with as much blindness as possible. You know what I mean? Just really dispassionate. So I appreciate that about Lally, but unfortunately, you have unscrupulous attorneys like Jackson and Yannetti who aren't going to play by the same rules, and at some point you have to kind of meet them at their level.
Yeah, I agree. And normally in any other normal trial, Lally would be, an A plus, because he's smart, he understands the material and everything going on. But I think there were so many factors in this trial and so many balls he was juggling. He just couldn't do it all. I mean, it's perfect in where he's working right now. He can concentrate. He has great questions. He knows the material. So I love to see that he's in the role of, providing direct exam for these witnesses that he's been tasked to do.
Can't want to talk about, nobody knows the case like Adam Lally. That's what I would say, that out of everybody in the entire world, the one person that knows this case the best inside and out is Adam Lally at this point. He had to learn so many different disciplines so quickly, right?
Hi, Matt.
Hey, how's it going?
Good. You sound soft. There we go.
Yeah, it's like something's missing here. So I was looking at, I saw the Jessica Hyde thing, which I think is absolutely ridiculous. Did the judge give any indication of how she was going to handle that?
No, she said she needed at least 30 minutes and already kind of
Hmm.
questioned if Hyde could stay an extra day.
So ridiculous. I mean, they're going to present that right before she comes to testify. No, the judge should just be like, no.
Yeah, it's disappointing. I mean, we all know the biggest thing she's concerned about is she doesn't want to, have anything be workable on an appeal. And so
Right.
she's absolutely the continuum of what is being allowed on the defense side is far, far to the side of the defense. But she shouldn't let the case in or anything. I mean, you might have heard me, Matt. What I believe is she should be able to be crossed about, has she had any issues? And then she can answer what was the issue, what was the jurisdiction, and what was the determination. That's how it should be handled, as opposed to putting the case in and trying to drag her through the mud, especially when it's a non-issue, meaning
Right.
different issue.
Yeah, I find it really, I mean, I don't know what she's going to testify to. If is it just the 227 search or what? I
It
mean,
sounds like the big issue is that there were no deletions. That's what she
Yeah.
was going to speak to. I don't know if there's anything else encompassed in there, but that was something that came up during this hearing.
By the way, off topic a little bit, Matt, I love that you have on a pink shirt. I was on court TV and I wore a pink dress, and Julie wore her pink blazer. And I'm not going to let anybody ruin the color pink. Like, pink does to me to be Karen Reed.
I'm reclaiming it. I'm reclaiming the pink.
Yes.
Taking it back.
Exactly. I don't know.
Oh, Victoria says you are pretty in pink.
I love that movie.
It's a classic.
Yeah, I was seeing something like on TikTok. Have you seen on TikTok where they have like all the people from those 80s movies and then it shows them age with the AI and like what they look like now? It's scary. It's scaring me.
Is it accurate?
It turns them into their actual picture, but the way that it does, I don't know. It's like, it's weird. It's shocking.
I feel like Molly Ringwald just doesn't age.
Yeah, she looks, well, when you see her, how young she used to look, she looks a lot different. But yeah, she looks good.
Oh my gosh, I have to say it. J15 said it. I'm going to reverse it. Isn't pink the new orange?
Pink
For
is the
those-
new orange.
Yeah, I don't know if you've seen them. What was that show? Is it Black the
Orange.
New? Say it.
Yeah, orange is the new black.
Orange is the new black. So I don't watch a lot of TV other than sports. And I was actually on the FBI director's detail. Anyway, long story short, we had to be up all night long on standby at a particular venue. And the guys are like, hey, have you ever seen the orange is the new black? I said, guys, I don't really watch TV. They said, we are binge watching it. We watched every single episode of that first episode. I have to say it was pretty darn funny, but you have to have that sense of humor like I have. I call it a Pulp Fiction sense of humor.
I never really got into the show. I read the book that the show was based on. I don't know. I mean, is that still running? They probably ran out of source material pretty quickly.
Yeah, I mean, I watched it for a few seasons. I guess it was decent, but then yeah, it got kind of old, but it was kind of funny.
Oh, the first season I thought was great. I never watched it after that, but maybe it was because we were just up so late all night with zero sleep, waiting for an incident, which thankfully never happened.
I just feel like that's not like Karen's prison experience would be a lot less glamorous and interesting.
Yeah, she's just gonna get shanked the first day.
I mean, I think honestly, if she's convicted, let's just speculate right now. She's convicted on count 2 and count 3. Just throwing it out there as a speculative. What do you think this judge would give her?
I think she's gonna. I would expect the most she gets is 5 years.
I totally agree. That's the number that comes to mind. 5 years is probably all she's going to get for a man's life, but I agree with you.
Yeah, I can't see it being more than that. And, I mean, she's going to appeal no matter what. And that's why it's like, do we really care? They're going to have an appeal. They've already been appealing every decision. So, I mean, if she appeals, isn't she just going to get another trial?
No, but I think you're like, just because you appeal doesn't mean that you automatically get a new trial. They would have to, she would have to appeal it. They would have to find to overturn, grant her a new trial. I don't think that's happening. And I'm pretty sure you have to stay in jail pending your appeals. Like they don't.
Yeah.
You do.
And I mean, 5 years, by the time it's done, she'll be out. So that's why it's like, whatever, just get her in there.
I
come on,
think she
Finoni.
should get more than 5 just because of all the circumstances. I mean, she shows absolutely no remorse. She blamed a bunch of innocent people. I mean, the judge is obviously aware of that.
Yeah. Yeah. If she gets on top of it, that witness intimidation, it could be like 20.
Oh, I was like, if she ends up with the witness intimidation and is convicted on that as well, like, yeah, she could get more than 20 years.
I just.
Doesn't want to do 30 days in county jail. Like, I mean, that's essentially, it's kind of ridiculous if you think about it. But yeah, she's pretty much fighting this hard to avoid, what could potentially be as little as 5 years in prison. All of this.
I mean, OUI manslaughter is probably, I feel like that's like a given, in my opinion. And then it's like murder, maybe. I just don't, I mean, if they can prove that she went back to the body, then maybe. I just don't think that they proved it in the first trial, so I don't know if they have more evidence to show that.
I think they have to prove, they have to prove number one, that, she, took deliberate action.
Enter your participant. Please enter the pass.
I think they have it. I guess is my point.
You have joined the meeting as an attendee and will be muted throughout the meeting.
Please be seated, court is in session.
The host would like you to unmute your microphone. You can.
All right. I appreciate the time. I appreciate people's patience. So in reviewing the rules, I look at Rule 2. So Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so upon reflection and consideration, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So that's my decision. So bring the jurors in, please.
You are unmuted.
Chrissy, do you want this under that?
Put us back in session. You may be seated.
Jurors, I appreciate your patience. So your next witness, Mr. Brennan?
The Commonwealth calls Jessica Hyde.
Just wait. Call that officer right there.
Follow me, please. Face the clerk and raise your right hand, please.
You solemnly swear the evidence given to the court and jury in the case now and here is the truth, the whole truth, and nothing but the truth, so help me God.
Yes, I do.
Good morning.
Good morning. Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you. Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde, Jessica, space Hyde.
What do you do for a living?
I'm a digital forensics examiner. I'm also an an adjunct professor at George Mason University, where I teach mobile device forensics in their graduate program. I also own a digital forensics company that does training, services, and research.
In addition to teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University,
I'm
not
sorry.
Georgetown, but thank you. I also teach, my company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, et cetera.
Do you engage in any other type of academics or research?
I do. I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which is a body that reviews practitioner-created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer
Oh, I'm so sorry.
What does peer review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are three types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work been peer reviewed in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items. The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken, as well as I have a master's in digital forensics from George Mason University. A master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold the NWC 3CFE, which is a Certified Forensics Examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
How do you teach private digital forensic examiners? What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching, but I also have a team of instructors. So for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic data analysis seems like a broad field. Is there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
I want you to just give us some very basic, very general and brief background. When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
Is there any shortcomings or dangers in simply relying on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data is stored as, it doesn't tell you what that data means, and that's where you need a forensics examiner. Tools don't necessarily understand how the data got there and what causes the data to exist, and that takes deeper and further human analysis, as well as, if you think about it, if on your phone you can go to the Google Play Store or the App Store, and you can actually download millions of apps. There's like 6 million apps between the two stores. Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Were you asked by the Norfolk County District Attorney's Office to look at and analyze a phone that was related to a person by the name of Jennifer McCabe?
Yes, with a very, very specific scope to a specific date range.
Were you asked during that scope and date range to analyze it and provide an opinion about whether there were any user-initiated deletions of any web searches or Safari-type searches?
Yes, I was asked to look for deletions of Safari searches within the scope of the time frame that was dictated by the purpose of the exam.
Were you asked to look at the phone device and determine whether or not there were any user-initiated deletions of phone calls on the device?
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Did you ultimately have opinions on both of those issues?
I do have opinions on both of those issues. That's correct.
And in engaging in the efforts to answer those two questions, did you necessarily have to review and analyze a web history that included searches on January 29th, 2022 at 2:27 a.m.?
I did analyze web searches that occurred at 2:29 a.m. on local time here in Norfolk on January 29th, 2022 from the device I was provided. Yes, not the device, the forensic image for clarity.
So before we get to the two opinions that you were asked to consider or what your opinions were after analyzing the data, I want to begin by giving the background and having you share with us your analysis and your observations and opinions about the search on Safari relative to this 2:27 timeframe. Before we begin that, let me just ask you one question. Did you do anything to ensure the integrity of the data that you were looking at?
Upon receiving the forensic image, the first thing I did was I did what's called a hash of the image. So a hash is an algorithmic representation of a file. So a forensic image, all the data from the phone, it comes in one file that can then be extracted and have the rest of the data. That singular file that's received, there's actually three, but focusing on the one that has all of the data, that archive file, you can run what's called a hash algorithm against it. There's actually multiple hash algorithms, and I hashed it, and then I validated that hash to the document that was provided along with the image file that contained the hashes that were contained in. Those hash values matched. Now, just for clarity, if you change one bit in a file, it will not have the same hash. So the hash provides integrity, and having used both hashes, which are available in that report, and ran two different algorithms, they both matched. Additionally, I reviewed the PDF that was received for signs of alteration. The PDF that comes with a Gray Key report is not signed by Adobe Acrobat. However, I was able to take that PDF and then examine it just like I would a phone. So I'm using the same techniques on the phone. Using a tool called EXIF tool, I was able to learn a lot about the creation of that particular PDF. And what I was able to learn about it was that it was created by, it's labeled it as being produced by Grayshift using a particular code-based application to create the PDF called PYF PDF, standing for Python Framework PDF. It is on, it's a program that you can download, and developers who create tools like Magnet Forensics, who owns the Gray Key, utilize that script, which is why it says it's produced by it, to create the actual PDF. That's what the evidence there in the data tells me. It also contains a time of when that is created, and that time was February 2nd, 2022 at global UTC, that's the global constant time, think what's in the UK, at 22:49, which local time would be 5:49 p.m. So that says that it was created approximately 2 hours and 45 minutes after the document said the image started, and it correlated with the document information. So that provided some level of certainty that that document was factual. And on top of that, I further opened the file of that PDF in what's called a hex editor, which lets me see like every byte, every 1 and 0. And from doing that, I looked for tag markers that are made sometimes in some modifications of PDFs called XMPs, which is Adobe's format of markup. And I did not find any evidence of those tags.
When you're trying to determine whether there's integrity in the data, are you able to tell whether or not there's been any alterations or tampering before the item is put on the Gray Key machine to make the extraction?
That would be when you're talking about if the physical device had been manipulated, is that correct?
Yes.
I cannot tell if the physical device has been manipulated prior to it being imaged. I can only validate if the image was correct. In theory, all of the data of anything that you did on that device would still show in the evidence of device logs and whatever locations that were touched or communicated with. But at that point, it's the same as any user interacting with the device itself.
After the phone's extracted or at the time it's extracted, does it have the history of the device on that extraction?
Could you rephrase?
Yes. At the time the phone is extracted and the copy is made in the PDF and the digital copy, does the digital copy and the PDF contain the history of searches and calls and other items on that phone?
The forensic image itself contains a variety of different artifacts or traces that are left behind by activities that a user does on a phone. Yes.
You use the term artifact. What does that mean in a basic sense?
An artifact is any type of evidence that is left behind on your phone of an action. So, for example, if you receive a call, there are multiple places in the phone that show that a call was received. That can be in the call log, that could be in a notification, that could be in a unified log that tracks the activity that the phone's doing. There's multiple locations, and each one of those residue of the fact that the call came in, that's what I would refer to as an artifact. So you could have an artifact not just about a call, about a web search, about taking a photo, any action you take on your phone may create an artifact.
Before we get into those two questions about any alleged deletions from Safari, a Google search or an internet search, and any alleged deletions of phone calls, I want to start with your explanation or your sharing how the timestamp works relative to that search beginning at 2:27 a.m. on January 29th, 2022.
So for clarity, there's more than one search that happens actually at 2:27. There is some activity that's looking at, and I don't want to mispronounce the name of the town. I'll try Hockomock Sports, looking at activities for the sporting events at that school system, I assume, or county location. There is a timestamp for the search "Ha's long to die in cold." However, that timestamp isn't about active searches. It's about the time that a tab was either opened or moved to the background. So "Ha's long to die in cold" is the most current search in the tab that you opened at that was opened at 2:27. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab or you can open a new tab. A new tab was opened at 2:27 a.m. and that search was done there. Another tab, actually at 2:27, was moved to the background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video. So those two searches both exist as what's called browser state searches, but that browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background, or if it's never been moved to the background, the current search. So the time in the instance of the "It's Raining Men" video is the time that that video was moved to the background and the new tab took over as the tab that's active. And that tab, the last search done in that tab is "Ha's long to die in the cold," because that database holds the current search. It constantly gets updated, and the time that the tab was either opened if it's the first time it's opened, or moved to the background if it's an existing tab.
Did you put together an exhibit that would help explain some of the different databases?
I did put it together an exhibit that would show that.
May I approach?
Yes.
Handing you a piece of paper. Do you recognize that?
I do. This is table 1 from the first report I created on this case on the phone that I was told was for Jen McCabe.
Is that the exhibit that will help you explain?
It will.
I move this to evidence.
Could we approach you? Or not that bit of jacket if you want.
Come on up.
Before we look at any chalk, I want you to explain the entire basis for that chalk and your ultimate opinions that are reflected in the chalk. So let's start from the beginning.
May I
And,
look at my copy of the chart or no?
Why don't I just
Your
ask
Honor,
you?
may I?
See if you can answer the questions and if you can, first.
Yes, Your Honor.
When you looked at the phone to analyze it, were you trying to determine when a particular search was made, specifically the search "How long to die in cold"?
Correct. I was looking for two searches, both how long to die in CIKD and how long to die in cold.
So as a forensic examiner, how do you begin the process to try to identify and determine when that search is actually made?
So the first thing we would want to identify is what application was being used at the time to make the search. So looking at that date time stamped, it was able to, on that date, be able to determine that Safari was the application that was being used as the Google browser. And then you would begin looking at the artifacts for Safari, both those that are parsed by the forensics tools, but then further looking into the data structures that hold that data itself, and then ultimately conducting testing to determine why a certain artifact exists.
So you mentioned the beginning step is the forensic tool or tools. Did you use forensic tools to get information or parse any data regarding this potential search at 227?
Yes, I use multiple forensics tools.
Can you share with us the multiple forensic tools that you used?
Absolutely. I used Celebrate Physical Analyzer. I used Magnet Axiom. I used just the tools I used at first. I used iLeap. There are further tools I used later, but those were the three that I started with.
What tools did you use later?
Later, I used specifically, I've used Sanderson's Forensics Toolkit, the forensics browser in Sanderson's Forensics Toolkit, which helps exploit SQLite databases. And then I further reviewed in a tool called Rabbit Hole.
To begin with, Celebrate, is that a tool that you're familiar with?
Yes.
Is it a commonly used tool in the industry?
Yes, commonly used mobile forensics tool.
Is it reputable?
Highly reputable.
Why did you use Celebrate?
I use Celebrate because on any mobile exam, I'm going to validate what is captured by Celebrate and Magnet Axiom because they have the most robust parsing of what is in my tool arsenal. And then I would also follow up with iLeap closely behind because iLeap has a lot of artifacts that aren't supported by either of those tools. Using a variety of tools is going to give you different coverage, and each tool has a different perspective on how they view and display data.
You said you also used Magnet Axiom.
That is correct.
Is that a leading forensic tool as well?
Yes, that is also a leading forensics tool.
Are you familiar with that company?
I'm very familiar with Magnet Forensics. I was actually their director of forensics for 5 years, then continued to consult for them for an additional 2 years under my company Hexordia, and my company continues to be a reseller of Magnet's products.
You mentioned different tools may present information a different way. Do those tools change the underlying data at all?
That's a great question. So when we're talking about the results that a tool shows, the tools maintain the integrity of that original forensic image. And that's actually something we verify as we continue through our exams to make sure that the underlying data hasn't been changed. There are some tools, I did use some other tools, I apologize. I also used ArtX and Mushy. But ArtX is capital A, lowercase RT, capital E, lowercase x, and then Mushy is MUSHY. You're welcome. I'm sorry, can you repeat the question? I got this, the spelling threw me off.
I mentioned, or I asked you about using multiple tools and whether or not the use of different tools changes the actual underlying data.
So the actual underlying data is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Celebrate, Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the tools presentations and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundations paper from the National Institute of Science and Technology that states the foundations of digital forensic science, it states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics parsed results.
Does software update regularly?
The software updates all the time. Typically, we get an update about once a month. And to be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Celebrite tool to analyze the 227 search, did the search How Long to Die in the Cold have a timestamp on it?
There are actually multiple artifacts for How Long to Die in Cold. Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that How Long to Die in Cold. Only one of them is associated with the 227 timestamp, but there are other instances of evidence of that was parsed by Celebrite.
Is there any danger for an untrained eye to rely simply on the software when looking at a search like this, How Long to Die in the Cold, and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that tab was backgrounded or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University in their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
You mentioned that Celebrite showed the search on the report as How Long to Die in the Cold with the timestamp of 227. Is it 227:40?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrite of last year, Celebrite made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
Is this ambiguity reflected in other types of software?
Could you rephrase, please?
Sure. For example, when you did a report in Axiom, did it have similar reflection in the report?
Objection, Your Honor.
Ask it differently.
Did you run a report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrate really show their data very, very differently. So Celebrate takes a perspective of alerting people to possible deletions by annotating either a question mark or a red X next to artifacts that come from different areas. Magnet instead marks if the artifact was parsed or carved. I feel like now I need to explain to you parsed or carved. So parsed means that the data was where it was expected to be found, and the algorithm was able to cleanly see that this is there. Carve means that it had to run that algorithm against the data structure as a whole and found it as a partial result. So it carved it out, went and found it instead of it just sitting there exactly where it was expected to be, and shows you both the results. So it'll show all of the results of, in this instance, the sessions, tab sessions, but the data browser DB, the tab state, it's going to, instead of telling you this has a red X, it'll instead say it was carved. So it's a different presentation of the same data.
So I want to talk about deletions in a little bit, but I want to get back to the 227 search.
Sure.
So when you produced or you looked at the report for Celebrate and it showed this timestamp as well as the phrase, how's long to die in the cold, where did you look? How did you make an analysis to determine whether or not that search was actually made at 227 or another time? What was your next steps for us?
So in looking at that timestamp, the first thing I did was actually go and look at what literature exists on the artifact, if anybody had reviewed this artifact before. I also created my own data set and tested how we could get what that timestamp means. So if I make a search in a tab and then I make another search in the tab, which timestamp is it? If I make a search in a tab and then open a different tab, what changes? I also looked at the documentation in the artifact reference guide for Axiom, which does state, it describes that timestamp as the time in which the tab is backgrounded. And it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Did you specifically look in any databases or for artifacts in the data to help make an analysis of when this search happened?
Of when the search happened as a whole? Absolutely. So there are multiple databases that I looked at that show search information for Safari. So I looked at the plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the Knowledge CDB. The Knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So it takes in information that Apple wants to take in, including browser history, and it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms for commonly searched items.
When a URL or a search through Safari is typed in, or if it connects, does it leave a trace in different parts of the computer or the phone?
Yeah, so when you actually do any search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use. Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure like looking at your banking information. You may intentionally use a private browser. For Google users, this would be the equivalent of incognito in Google Chrome. and you may intentionally use that. And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches, and some exist for private searches.
And in this case, this phone, was it on non-private or private?
So specifically the two searches we're talking about, how's long to die in cold and how long to die in CIKLD, excuse my differentiation there. Both of those searches were done in non-private browsing.
So they weren't hidden.
I don't understand the question yet.
Was there any applications on to mask those searches?
Not to the best of my knowledge. I did not see any.
We began with the 22740 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 623 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you saw that, do you look on the same tab or a database? Where do you find that information?
Fair. Understood. So all of those databases I was just mentioning before, we're looking at all the parse results from all of those. And I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs for browser state DB, cloud tabs artifacts, History DB, Mobile Safari plist, Knowledge C, each one of those. And then I was combining them to timeline out the activity.
At 62351, did you look into how long TIDIE in CIKD?
So that would be the next thing that we see after the Apple suggested term of how long to digest food. That's the next thing we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in Knowledge C and one is in the Mobile Safari plist.
Can they appear in different rooms in the data bank in different places, the same search?
Searches appear in many different places. They can leave traces, such as that Knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the Knowledge CDB, what Apple's trying to learn about you, as well as in that Mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD.
And finally, at 62447, did you identify any artifacts with that search that appears with the timestamp of 22740? Did you find the same?
Correct. At 624, we have two timestamps in the same two locations for how's long to die in cold, the Knowledge C and the Mobile Safari plist.
So based on your analysis in that issue, did you come to an opinion whether or not the phrase how's long to die in cold was actually searched at 2:27 a.m. on January 29, 2022?
There are no artifacts.
So the answer is yes or no.
Can you repeat the question,
Yes.
please?
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase how's long to die in cold was searched at that timestamp tab of 22740?
Yes, I came to an opinion.
And what is your opinion?
Objection, Your Honor.
Rephrase the question as to the opinion.
I'm sorry?
I'll see you at Sidebar, Mr. Leslie.
Thank you, Your Honor.
Howdy there.
Another sidebar.
What is your
Another
opinion?
sidebar.
He can't ask her for her opinion. Like, I don't even understand that.
I'm
Did
shocked
you-
that that case, that Maryland case was excluded.
Oh, Bev is growing up.
Yeah.
Just before she retires, she'll finally become a good judge for the last minute.
Ouch. That's rough. Did you guys catch Hyde saying that in reference to that 227 being found? She says, "Yeah, sometimes some of my early students make this mistake." It's like, come on, man. The people that buy this crap, right? They're following a blogger who's following a guy that worked at didn't work at, worked next to McNasty's, right? And you have this lady up here talking about the company she owns, runs her pedigree here, and she makes nod that some of my early students make this mistake too. Wow.
And he
It
doesn't even
happened,
have a bachelor's
everybody.
degree or certification, so he's never even taken the classes that she teaches. Like, I think that's like a mind-boggling. And I know that tonight I'm going to go on TikTok and everyone's going to be like, "It happened at 227." Like, the people that believe this bullshit are morons, or they're like evil. It's one or the other. They're either evil and they like Karen Reed and they wanted to get away with it and they want to vilify all these people and they want to feel justified dehumanizing all these people, and they're evil, or they're just dumb as hell, or a combination.
A little bit of this, a little bit of that. Big time. Big time.
It's like
bunch of evil
No.
morons.
Conspiracy is a hell of a drug. I think a lot of these people are
Yes.
having a hard time detoxing. That's all. I
Mhm.
would have let it go the first trial if I were them, but here we are. They still are not letting it go.
No.
That's what evil is.
I had a whole discussion earlier while you were gone about my how uncomfortable I am with the word evil and like the nuance behind it. But like I think like I'll say like Karen Reed looks like she's being consumed by evil, but I stopped short of calling her evil just because like I don't know. I think she's just a really dysfunctional dumpster fire more than anything else.
Well, she can't see her mirror neurons, so she doesn't have empathy, and that makes her evil.
Wow. You do not have enough neurons. You're evil. Oh wow. Yeah, you're scientific.
Definitely not a good person. I would not characterize her as a good person at all.
No. But I could see the argument for evil. I mean, I can see it, man. I can definitely see it. Big time. So I'm late. Did I miss anything crazy? Did we see any more clips? Did I miss a clip?
You did not miss any clips, so good news there.
All right.
It's been kind of slow this morning. They're chugging along. They just got to Hyde, and already there's an issue. So
I want to hear about. I mean, it seems like she's just going to be talking about the deleted calls or maybe deleted anything from her phone. Because I know from looking at it, they're consecutive. I've always known that those are from the recent calls, and that he was just calling them all deleted.
Right.
Because it's like the 911 calls on there. Like, yeah, she's trying to hide the 911 call. Come on.
Right. Can't let anyone know she called 911.
Dummy up, you evil morons. Come on now. Get with it. No, we're not on. This isn't. We haven't seen Cross yet, right? We're not on Recross.
No,
right?
she's still on direct. She's like kind of just beginning direct. They just have a million useless sidebars.
Yes. Yeah. Noticeably.
Yes,
So,
WD-40 says you missed it. Leslie's attempted Hail Mary. He tried to pull out a case where her testimony was deemed not admissible, say that it made her unreliable and not credible, and wanted to bring that in.
Wow.
That was denied. That was denied.
Okay.
Yeah, she seemed like upset when she first came in, but it could be because of this case. I don't even know if she'd know about that, if they would have told her that was going on in the courtroom or not. But just because it's not admissible doesn't mean she's incorrect either. It just means that the court was like, there's not enough information to say this is evidence, right? Because like mobile data is brand new, just like a lot of the genetic genealogy is new. Like that stuff is being challenged by courts everywhere right now. So
gotcha.
It's just a thing.
And it's a completely different scene.
Are we assuming is Alessi going to be crossing? You think?
Oh my God. God bless her.
Yannetti did it last time, and he didn't. I didn't think he did a good job. But I also feel like she gave some weird answers that people could clip and be like, look, she said that it's possible. Because she was like, well, I could say you can't rule out something that didn't happen. She said something about pandas or something.
Yeah,
I just remember it was like,
I remember that. I definitely don't see them using Jackson. But again, like she's very likable, right? So that they're going to be on eggshells trying to cross her aggressively.
It might be a
they're
last
going to
season.
look insane.
Mhm.
Yeah,
Everyone's
I
saying
believe
last
they've already lost the jury to a large degree with their style of cross. Hyde comes across, I mean, obviously professional, knowledgeable, but she's also really likable. So she's going to be you're going to be hard pressed to make her look nefarious, right? They're going to have a hard time there framing her up.
Yeah, she just changed all of our teaching styles, and she's teaching students wrong just so she can frame Karen Reed.
Yeah, big time.
Like she changed her entire curriculum to frame Karen Reed, so that there's like a whole generation of bad.
Yeah, exactly. Screwing up
examiners.
cases all over the place just to get Karen Reed, right? Yeah, it's part of the conspiracy.
Maybe she's just jealous because Karen has no ass.
Oh man, it could be it. Could be it. I can't get that out of my head though. That sometimes my early students make that dumbass mistake, but
I know, I like
professionals shouldn't. Smart people shouldn't. Real journalists shouldn't. But
I want her to
we
say
are.
more stuff like that, like, well, uneducated people.
Yeah, I know. That's what I was thinking. Yeah, exactly. It's like get them. Stupid morons. Sometimes they get caught up in this dumb shit, but
Richard Green's a buffoon. Like everything about with the way he presents. I'm actually
he
looking
fumbled
forward
through the whole thing.
They better call him again.
Yes.
You've explained to us the analysis you engaged in and the process you engaged in. In forensic data analysis, is there a methodology that you use, not just looking at the printout of the programs, a methodology you use that is accepted in the industry for experts to analyze this data and come to your opinion?
Absolutely. Beyond looking at what was in the tool results, I further looked at those databases independently and conducted testing of the artifacts.
And in addition to what you did, can you share with us how and why this methodology is accepted in your practice as forensic analyst?
This methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence, who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and Technology, NIST, Organizational Scientific Area Committees, OSAC, Digital Evidence Subcommittee, where we also produce guidelines such as the data set guidelines for generation of the guidelines for data set generation, which is how you do your actual testing and creation of data sets. And I was also a part of the subcommittee that drafted that. So I'm intimately familiar with the accepted policies and procedures because I am also a member of the groups that help author these, as well as review them and look and use them.
Are there articles and guidance in the industry about this particular practice of analysis?
For analysis, just for clarification, you're talking about for analysis of Safari artifacts, of mobile forensics, of browser state DB, just for clarity on the question.
Let's work our way through it. How about
Sure.
through Safari?
For Safari, there are multiple different blogs that talk about Safari, as well as I have analysis of Safari through classes I took, such as SANS 4508, which is 518, SANS 4518, which is the Mac and iOS analysis course, which I took.
How about the specific guidance regarding searching the different databases for artifacts?
In terms of methodology for digging into databases,
Yes.
is that correct? There are multiple, I've taken courses throughout my master's program, courses on how to analyze digital forensics artifacts, including mobile device forensics, throughout my GIAC certifications. I've taken multiple instructor-led courses on how to do these, as well specifically that cover mobile Safari history in mobile forensics at GMU in his master's program as part of the SANS 4518 class. And in terms of data structures, I've taken study on how to analyze databases like SQLite and PLIS are covered in those courses.
There are books on study on this methodology.
There are multiple books on digital forensics, many of which I've read, and including books specifically on analysis of SQLite databases, such as Sanderson's SQLite Forensics, which is probably the most authoritative because not only was it written by Sanderson, who makes a tool, it was tech edited by 3 renowned forensics examiners, as well as Dr. Richard Hipp, who created SQLite itself.
The methodology, the technique you use to look past the reports and actually look at the data to make your determination and arrive at your opinions, is that methodology regularly accepted within the forensic data community?
Absolutely. Again, using the methodology from the consensus-based documents from the community, from the Scientific Working Group Digital Evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings from Sanderson's book.
Now, you share with us that you had an opinion regarding the timestamp and whether that it was applicable to the search term, "How's long to die in cold?"
That is correct.
Now, I want to ask you, to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase "How's long to die in cold" was made at the time of the timestamp 2/27/40?
It's the last time, Mr. Massey, on this issue, okay?
God damn it, Alessi.
They really don't want this to die.
Stop bringing in the truth. It's bad for our guilty ass client.
Right.
What was the last question that he just objected to?
The 227 search.
Yeah.
Her opinion on the 227 search.
Why?
Right. They just really don't want that to die. That's what it is.
Yeah, they're still hanging on.
It's so pathetic. I mean, I just feel like this is just like such a disgusting defense.
It is. I'm kind of surprised they're still hanging on to it, period. I mean, because it's I don't think it's going to pan out
retool.
well.
She was going to retool, I thought.
That's what I thought too. Yeah, right. Yeah. Because then they might choose between me and Jen. Oh no. They must. What a weird thing to say, right? If they don't believe it.
She could have just been like, I hit him and knocked him down. He didn't look mortally wounded. He was fine. He gave me the finger, flipped me off. I drove away, and then he must have got up and slipped and split his head open. Like, she could have said, I mean, there's so many different things that they could have went with. But like, to vilify all these people.
That's not insane enough, man. No, we need to upend many people's lives and careers and relationships. And that must be done, apparently.
Karen's not happy unless the maximum amount of people possible are suffering.
Which brings us back to the possibility that she is pure evil. Right? Right? It's a case for evil. And some people, she's missing some neurons too, so we got a scientific leaning on that too. So.
Well, the ancient people used to say that your colon is your conscience, and she got that removed. So,
whoa,
really?
Man, now we got ancient thought weighing in on this too.
What culture?
This up as a poll.
Tell me more about this.
I'm trying to think of what it is, but it's like something about it's your root chakra, right? There's a lot of things about the colon. So like there's the heart, the colon, the brain, but like the colon is like your base. Like it's your I'm trying to think of how they like word it, but it's like, because you know how like you feel it, anxiety and stress through there. Like there's a lot of things that resonate through your stomach, and so
Okay.
I don't know, but now I want to like research it a little bit better.
I just
to remember
Googled
it.
it, but I would have to do like a deep.
Yeah.
It's like
See,
your
this is
second
what I
brain.
mean.
They
I
call it the second
literally,
brain.
I literally just Googled, is your colon your conscience? Like people Google weird shit. Case in point, right there. Right.
Yeah. What did Google say?
It's giving me information about colonoscopy.
Some ancient tribes believe this. So we got the past, present, and future weighing in that she is pure evil. Should throw that up as a poll.
I'm just saying,
Is
if
she
someone
evil?
were to get murdered in my family or in my vicinity today, and they went and
Mhm.
they got my phone and they saw that I was Googling, is your colon your conscience? It might raise some eyebrows. I'm just saying, they'd be like, oh,
Right.
that's why the
Oh,
how
man.
long to die in cold thing never really rattled my cage that much. Like, I need more than that. I wouldn't want to convict an accused person on just something like that. You know what I mean?
Yep.
Surely don't want to
same.
disparage somebody who hasn't even been accused of anything with that.
Yeah.
So my result is yes, the concept of the gut having a second brain or being connected to emotions and mental health dates back to ancient cultures. While the second brain is a modern scientific one, ancient civilizations like the Greeks and the Chinese recognize the gut's role in overall well-being, and it's linked to mental state.
Huh. Well, there you have it, people. They took her conscience out. Now we can get. So don't send emails to Kevin, by the way, that people, all you folks out there that don't have colons, we're saying you're evil. We're just saying she's evil. So, it's all right.
Contact the defense with this theory.
Yeah.
All right, go right ahead, Mr. Brennan.
I'm now going to ask you for your first opinion. So you shared that you have an opinion about whether that timestamp 22740 was, whether or not that was the time the search how long to die in the cold occurred. Can you tell us to a reasonable degree of scientific certainty your opinion about whether that search, how long to die in the cold, occurred at 2:27:40 a.m. on January 29th, 2022?
Same objection, Your Honor.
Okay, the objections are overruled.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Do you have an opinion to a degree of scientific certainty whether there was any other searches similar to how long to die in the cold that evening on that tab?
Objection, Your Honor.
I'm going to allow it.
May I first inquire, you meant morning, I
I'm
assume?
sorry, that morning, yes.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize. I disrupted my own train
Do
of
you have
thought.
an opinion to a reasonable degree of scientific certainty whether there were any other searches on that tab before the final search at 6:24:47, how long to die in cold?
Same objection, Your Honor.
Overruled.
Just ensuring that I have the question correct.
Please.
You're asking if what else occurred in that tab prior?
Yes.
That I cannot say with a clear degree of certainty.
Did you develop a chalk that I showed
did.
you earlier?
Yes.
Like to approach?
Yes.
Again, I show you. Same document, you recognize it?
Yes.
What is it?
It is the exhibit that I created that was labeled Table 1 in the first report I had delivered.
And does that provide information that will assist us in understanding your opinion?
Yes.
I'd move, subject to redaction, that this be introduced into evidence.
Your Honor, I have no issue with regard to the redaction aspect, but consistent with my prior objections, I would object to that.
Okay, I'm going to allow this into evidence. Your rights are safe. Mr.
Thank you,
President.
Your Honor. Appreciate it.
Exhibit 82.
Madam Clerk, 82?
Exhibit 82.
Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay.
Could we enlarge the first two? And we're going to need to get the right column in if we can, please. Thank you. Ms. Hyde, can you see it from there?
I can. Thank you.
If you can walk us through how this exhibit assists us in understanding your explanation and the basis for your opinion.
This exhibit shows the Safari artifacts and artifacts of Google searches in Safari related to the two searches in question, How Long to Die in CILKD and How's Long to Die in Cold, that occurred on the morning of November 29th, 2022 on the device under examination.
If I look at this chart and I see in the top left, it says 2:27:40 a.m. And then under the search term, it says, How's Long to Die in Cold. How do I understand your opinion that that search didn't happen at 2:27:40?
This document is showing you the data that is the parsed result. The source of that artifact that you see in the last column is a little bit cut off, the browser state db-wall file. That database does store how the data is stored, the search term How's Long to Die in Cold, with an associated MAC absolute epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
In the second row, we see a timestamp on the left-hand column, 6:23:49. And it provides artifact, the cache record.
Mm-hmm.
What is the term, and what does that mean under the search term?
iOS Safari cache records. A cache refers to something that a computer program wants quick and easy access to. When we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 6:23:49, we have a cache record that indicates that Apple suggested the phrase, how long does it take to digest food?
And then under that, 6:23:51, it appears it says a recent web search, and the spelling is changed. How long, TIDIEINCIKD.
So this, in reference to these two search terms, this is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the person inputting into the phone at that time continued to type out a phrase and finished it as how long, TIDINCIKD, which that is available to us in the mobile Safari plist, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line. So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing. It sees and holds your knowledge. It's an easy way to remember it. That's what I teach my students. So that Knowledge CDB tracks a lot of things for predictive purposes. And so 6 seconds later, it's logging that same search. So that search is being tracked in 2 places.
And so one search can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column, at 6:24:47, we again see How's Long to Die in Cold. And if you look in the first column, it's the same phrase. Is that a coincidence that it appears at the bottom at 6:24:47 and also appears up at 2:27:40?
As mentioned before, through testing of the artifact for browser state DB, that artifact will hold the most recent search that happened in the tab. So it is logical that HOS long to die in cold was searched at 6/24/18, tracked in that mobile Safari P list, repeated in Knowledge C. Knowledge made its tracking in the Knowledge CDB, and then that table for browser state DB, which again has the time that the tab was opened or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 227 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen because it's the update to what's in the tab.
You offered that the HOS long to die in cold is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty the time when that search was made?
Objection, Your Honor.
To a reasonable degree of certainty, I can say that HOS long to die in cold was searched at approximately 6:24 a.m.
Now, moving on from the 227 search, there are two other issues that you were asked to analyze. We talked about them at the beginning. Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, "HOS long to die in cold," was user deleted on that device.
So there's two really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes.
And can you explain how you came to an opinion that we'll ultimately share with the jury?
The first line in that exhibit, the ending of that, if you remember, it said browser state.db-wall. That's important. So we'll talk about that in a second. But the first thing I want to bring up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool, because that information was in that -wall file. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones, actually one of the most common, when that database stores data, it has two versions. The most recent version, and the version in use here, uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant and we're sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table. The chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log. The server grabs it from there. It's where data sits before it goes to the table. Just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza. Another table orders waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area. Waitress comes over. This pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right? We're deleting it. We're moving. We said it's not what we wanted. The waitress is removing it. She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log until the database is closed, and then when it's reopened, all those changes are made, both additions and deletions. So often when a phone is imaged, when we make a forensic image, the applications are still open, so we have those wall files. When we look in our Safari browser, the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table, but it's not in the table yet. So if when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger. right? Pizza got sent back, waffles and pancakes haven't come out yet. So when we get the data, we get two files. We get the restaurant, that's the database, and we get the serving area, that's the wall file. Just because it's in the wall file does not mean it's deleted. It means that that record wasn't where it naturally sits yet. It could be that wall file can contain deleteds and food or data that hasn't yet been delivered to the database. So the wall file consists of both. So an assumption that the data was deleted just because it's in the wall file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International actually has a section that explains this exact presence for SQLite databases about how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We refer to things in statement of recovery because we need to determine why it's there. So we can't say that it's deleted just because it came from the wall file. Some tools will automatically indicate to the examiner that they need to dig deeper into that. I did do further analysis by looking at the wall file. That particular item and it's a little bit more complex, actually exists on multiple pages because it moves as the database is being created, but all of them have the same unique identifier. So it's the same entry. It's not more than one search of Ha's long to die in cold. If there was more than one search that had occurred where it became the top element in that database, we would see that. There are, as I mentioned, other carved from the database, from the wall file elements such as the search for the YouTube video, It's Raining Men. Because at some point that was the last viewed item in a tab when that tab was retired right before, also at 2:27 a.m., but a couple of seconds before the Ha's long to die in cold search. So we can see that that table is put to the rear. The newest tab that's open, which is why it's in the wall file, it's the most recent thing because it's like our waffles and pancakes hasn't been delivered to the table yet. So it can sit in the wall file for that reason. That doesn't indicate it's deleted. The second reason is there is no user interaction in the interface to delete a tab. You can open and close a tab, and open and close tabs are tracked in that database, but you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So it could not be deleted by a user through the interface for that most basic reason.
So a user, could they delete a tab if they wanted to?
There's no actual option to delete a tab. For your web history, you could clear the cache, for example. Most of us are familiar with clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you can't delete the tab history. It's just what tabs are there. The device is tracking that.
When you looked at the software, whether it was Axiom or Celebrite, when you look just at the report, not the data itself, do either of those reports have any indication noting that that web or that Safari search is characterized as deleted?
The tools, Celebrite denotes it with a red X, which means that it is recovered. Axiom indicates that it is carved. In the same paper that I referenced earlier that I authored, there's a chart in there that shows the distinction between how different tools, some will use red X's, some will use question marks, some will list carved or parse. So every tool chooses to do that differently. That does not mean deleted. It means it needs further analysis.
Should an examiner who looks just at the reports of the software assume that if it is marked as recovered in Celebrite or carved in Axiom, should
an examiner should never assume something's deleted without doing a manual examination.
The manual examination, is that a method that's used, that's generally accepted in the forensic data field?
The NIST Science Foundation paper, as well as the data set generation guidelines, both speak to conducting testing to verify and validate, and it states clearly that an examiner is to verify and validate findings and to determine meaning.
So given that you've used multiple tools to look at reports regarding this phrase, how long to die in cold, and have seen indications or characterizations of recovered and carved, and in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable degree of scientific certainty whether or not the user deleted, any user deleted the phrase, how long to die in cold?
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion to a reasonable degree of scientific certainty whether any user deleted the phrase, how's long to die in cold?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
Finally, I want to ask you about your analysis of the phone records on this phone attributed to Ms. McCabe. Did you go through an analysis of the phone logs and the phone records on the phone?
I analyzed the call logs and the phone logs on the device that I was given, that I was told belonged to Ms. McCabe, yes.
Would a suggestion or a claim that a user deleted irregularly a number of phone calls, would that be accurate or inaccurate in your experience?
It is inaccurate in this instance.
Can you explain to us why and how you came to that conclusion?
Yeah, this is actually really interesting because of what it appears in the forensics tools and additional artifacts that I looked at that are not parsed by the forensics tools. So the call logs, when you look at it, it appears, I don't remember if it's 8:57 or 8:59 a.m. in my mind at the moment, but approximately either 8:57 or 8:59 is the earliest phone call we see on the 29th of January. We see no call logs before, but we do see FaceTime logs before. So if an examiner, again, was making assumptions without testing or reviewing, the first assumption might be, well, things must have been deleted because there's data that exists before, but not current data. So then you have to go, how do phone logs work? And again, create test data and review. What the situation here is that there are 3 types of call logs on this particular phone. There's regular calls, incoming and outgoing. There are FaceTime video chats, incoming and outgoing, and FaceTime audio chats, incoming and outgoing. The storage for that is actually 200 records. So you can only store up to 200 of each. Now, if you were a user of, let's say, WhatsApp or Signal or Telegram, those would each count 2 and they'd get their own logs. So when we look at the database for the number of calls between 8:59 a.m. or 8:57, again, I apologize, I'm not looking at that precise time, on the 29th of January in 2022, there are exactly 200 calls still in that record from then until the imaging of the phone. There are 199 FaceTime video calls and only 27 FaceTime audio calls. So the question is, how do you validate that that's what's happening? So we actually have call logs that we can pick up in other places for recent call logs in the last 7 to 30 days, depending on the exact version of the device and how the biomes are running. We can actually see incoming call logs, the number they go to, and if they're incoming or outgoing in the biomes. So we actually can see the history going back for the entirety of that day on January 29th till midnight. Again, my scope was from midnight until noon. So we can actually see all of the calls. They're just not all in the call history state DB. Now, the call history state DB, from a user perspective, that button on your phone doesn't say call history. It actually says recents. And what it's determining as recents is the most recent 200 of each category. Now, how did I determine this further? There is a running log that exists in a phone. It lasts about 3 days. It's called the unified log. The unified log tracks multiple things that are happening on the phone. In manual analysis of the unified log from this phone, I can clearly see each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days, but on this device, we do see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
Do you have an opinion to a reasonable degree of scientific certainty whether there was any user deletions from the phone call log that morning?
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing unified logs, that the system is deleting the 201st call every time a new call is received or outgoing.
Thank you. I have no further questions.
All right, can I see counsel at Sidebar regarding scheduling and a few things?
Refute that, dorks.
Her testimony is a little bit more limited than it was the first time, huh?
In how so?
I feel like she went into a lot more depth the first trial, or maybe I'm crazy.
I can't recall whether or not she went into more depth, but I don't know if it's because this is recent. I mean, it's happening right now, but it seems clearer to me the way she's putting it across, the way it's parsed.
I don't think that they talked about the deleted calls before. Did they?
I don't think they did.
Oh, maybe they did. I don't remember.
It's been a while, yeah. I haven't.
But now we know
I haven't
she
seen
didn't
it
delete them.
since then. Yeah, I mean, I like that one moment there. She says, "No, she didn't. No, that's not something that somebody can delete." I mean, that's going to be kind of hard to run up against, right? Like, no, but she did it. She's you know, she's McAlbert. They know how to do everything. They run the town. They have a giant conspiracy going on. They control the state police department, and they can delete things that no one else can, apparently, right? Like they're getting, the suspension to disbelief is going to get Olympic. It's going to be insane. Good luck with that, guys.
Yeah, I mean, I can already see the conspiracy chat is shifting to something else.
Oh, they have to, right?
They're like,
They're
well, what
gonna have
about
to.
Jen McCabe threatened some girl and told her to go eat a dick or something? I'm
Right,
like,
right,
well,
right.
I remember that. Like,
Somebody said that? Oh, wow.
I mean,
Damn.
this is
That's
about
rough.
Tom Beatty's daughter, because I guess, well, I don't want to say it, but apparently she does do that in her past.
Yeah.
Like,
I know what
she's
I know what
known
you're
for
talking
it or
about.
something.
Yeah,
I don't know.
There's yeah, I hear you. I mean, how?
But it's like they just jump to something else as soon as something's
All right,
disproven.
Ms. Hyde,
Absolutely.
let the jurors
The
have
pivot's
lunch.
unreal.
You can walk out after.
Thank you. Thank you, Your Honor.
45 minutes.
Thank you, Your
Jurors
Honor.
will recess for 45 minutes before.
All rise for the court, please. Jurors, close your notebooks, follow me.
Karen might not come back. She might be heading for the border after this.
Dude, Green, he's got to be like, oh man, I know I'm a fall guy. I know I'm hired because I have no reputation left, but everyone's gonna laugh at me. How can you not feel the anxiety of like walking, even just parking your car? You're getting ready to go in there and just serve up a plate of bullshit.
I wouldn't
knows it.
They should just back out. Like, I don't see how that's going to go over well. I don't think.
Just run. Yeah, run, Forrest.
Don't even bring it up. Don't even bring it up. Don't even have him.
Yeah. Holy shit.
I think it's going to make it worse.
Uh-huh. Oh God. Well, I can't imagine what the feral little blogger is going to be doing. What's his pivot going to be? You know, yeah, she doesn't know what she's saying. Yeah, like.
Well, last time they were all like, she shouldn't even be allowed to come into the court with that thing on her head. Like that.
I remember that, dude. Yeah. So, wasn't it something that's like base as it was like a terrorist comment or something like that, wasn't it? It was something real gnarly like that. Really pathetic. I mean, he used that last time. I just don't know. What are you going to say to this? What are you going to say to this? How the hell are you going to pivot you know, how are you gonna? I don't know. I just don't see an angle. I mean, yeah, you can attack people's appearance. You can do this, that, and the other. But what else? What else? This is
They're
trial
gonna
two.
ask
You
her
got to
if
step it
is
up.
this possible? You know, can you rule this out? And she's not. She's gonna be able to. Well, I can't rule it out because I can't see what other searches
Right.
happened before it on the tab. You know, so like
Yeah.
I think that's the only way that's the only thing they're gonna be able to say. But the 200 call thing, I think, is very strong, and that's what I was always saying about recent calls.
Yeah.
And you know, now it's there, and I think it's indisputable. Like the 201st call is deleted by the system. Like end of
Right.
story.
Right.
You
Yeah.
can't even
I mean,
argue
that
it.
was pretty. That was pretty blunt. She said, "No, I don't believe that was deleted by a person because people can't delete that."
Right.
And Richard
So
Green, what's he gonna say? Like, oh, I didn't know, because last time he was saying, oh, I didn't know that. Now I do. He's gonna say that about the
right.
recent calls. Like that's the most basic data
Yeah.
to
Yeah.
know that recent calls get automatically deleted. Like, you know what I mean? Like the only those calls are stored. Like he doesn't know that.
No, he doesn't.
He
When
should just not come to court. He should just off himself.
oh,
I'm just kidding.
take himself off the case. Yeah, I know. Yeah, totally. Yeah, he should definitely do. Yeah.
I mean, take him off the list, not off
Yeah,
the
that's I
the
know.
earth.
I know. Yeah.
Oh, I
Like,
completely took that the wrong way. I was like, wow.
I know.
didn't
I said it, and then I was like, no, that's not what I mean. But I mean, that's what I would do. Like, if I backed myself into a corner like that, I'm like, she's right. Like, what am I gonna say? Like, I'm
Yeah.
gonna ruin my entire reputation.
Well,
by,
that's
like,
the thing. It's gone.
in
It's
this
already.
high-profile trial. You know, be on
Yeah.
TV
No.
saying this stuff.
I don't
He's
think
a
I had much of a
mercenary, right?
Yeah, he didn't have a reputation to begin
Yeah.
with.
That's how
Other
come he
than
got hired.
Being the guy
He'll fall
that
on the
sexually
sword.
harasses waitresses at McNasty's and then
Right.
files false police reports. Like that's his reputation.
Yeah. Didn't he say somebody shoved him on the ground, but he just tripped over his fat ankles or something?
And it was like on video, and he pressed
Yes,
charges,
it was
and they
on
played it
video.
for him.
Yeah.
So he got
Yeah,
charged
yeah.
with reporting a false crime.
That's right.
And like, so like Alan Jackson is good about bullying people, and I think that's like what Richard Green was for, because in the Kevin Spacey case, he like looked into someone's phone, and then like they confronted someone with whatever it was, data, text messages, something, and the kid pled the fifth, so the charges were dropped because like whatever was on his phone was incriminating or whatever. But like, you know, who knows if it was even right, because Richard Green is just going to make, you know, he wasn't challenged. Like he didn't have to testify. He just had to write an affidavit. And so like we saw him on the stand last time. He was terrible.
Yeah.
So,
Yeah.
so
He's
good luck.
not good. He's ungood. Yeah. Good luck. Good luck. At least. I mean, you need magic. You got nothing. It's gonna be
I
ridiculous.
can't overstate that Alessi and Green is an unholy pairing. Like if that happened, I don't even know.
Dude.
Expect Armageddon.
Yeah. Are we gonna see a juror jump the fence there and go after Alessi? Stop it! No more. And with him in these sidebars, man, it's like someone fed him after midnight. I swear to God, he's on a tear this morning. You know what I mean? Like sidebar. Like holy shit, dude! Like, tell him your tits. What are you doing?
They really didn't want to talk about 227 again. That's for sure.
No.
Yeah, I don't even understand what the argument is. Like Alessi's just such a little rat.
Yeah, he's
like,
a
I just
gremlin.
can't stand him.
Mm-hmm.
And he's not too bright. Like he does find stuff, like, but like he found this case, but it like wasn't related. But he just rambles, and the judge is so annoyed by him because every time it's like he can't get to his goddamn point.
No.
And I think that's his like whole methodology is like he's so boring that like people lose track, and they're just like, how do I get this guy to shut up?
Right. Obfuscation through being a jackass. Yeah, totally.
All right, I'm gonna drop. I'll be back in 45.
Yeah, we'll be back in
Word.
45. All right, I gotta
Sounds
go
good.
run and do a couple things. I will be back as well, guys.
All right.
examination. Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking about. You have to move along from that Maryland case.
So with regard, do you recall another case from the state of Massachusetts, Arrington case, in which you submitted a pro se amicus? Do you recall that case?
I do.
And is it correct that in that case, you submitted arguments on behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but the friends of the court, you took a position in that quote, friends of the court brief, correct?
Took a position on the evidence.
Right, and the position you took on the evidence was that the frequent location history data is reliable and should be used. Is that correct?
The statement is that I do not have that amicus in front of me. It has been a year and a half since I've read it. But that amicus does discuss frequent location history records. And I want to be clear, it speaks to both bias on both sides and negative and positive of submitting it. It was an unbiased writing, and it was not specifically in support of the prosecution.
So you are testifying in this case on behalf of the prosecution, correct?
In this case, I was hired by the prosecution.
Right.
That's correct.
And the prosecution is paying you for your services in this case. Is that correct?
Yes.
And with regard to this case, you have been paid and have been on this case since May of 2023, correct?
That is correct.
With regard to the various reports that you have submitted in this case, you have mentioned one, which is a report with regard to the iPhone of John O'Keefe. Is that correct?
That is correct.
And you have, in that report, you have made a statement, have you not, that from 12:20:50 a.m. on January 29th of 2022 and after, there is no indication of interaction with the device. Is that correct?
There is no indication of user interaction with the device. There is all received until about 6:04 a.m. when there is again Apple Health data that picks up.
I'll ask it again. And you can feel free to turn to page 1529 in that report.
Page 15?
Page 1529.
The report is.
Would you like the
50
page of the
pages.
report or the page NDA number at the bottom? I can do either
Oh,
way.
I'm sorry. I thought you were saying page 15 in the report.
No. It's
I
NDAO
apologize.
1529 or page 7, whatever way.
Page 7. Okay, Roger.
Okay, so page 7, you see there's a heading interactive phone activity, correct?
Yes.
And at the top it says, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20.
Yeah, you have to
Slow down. Okay, sorry about that. I'm just trying to move it along, but I will be slower. I'll repeat, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. You see that statement?
Yes.
And that if you skip down, I'm going to skip a couple sentences to the paragraph under the chart, and this is the key part.
Okay.
It says, from that point, and I'm understanding that point to be the 12:20:50 a.m., correct? You need to say yes or no, I'm sorry.
Yes.
There is no indication of interaction with the device. Did I read that correctly?
That is correct.
So I am going to, and you believe that statement is correct?
Until 6 something a.m.
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct?
Can you answer that? Ms. Hyde, can you answer that, yes or no?
Did I read that correctly?
You read it correctly,
Thank
yes.
you. If we could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39. And it will be, thank you. And if we could go to slide 82, please. And Ms. Hyde, if I could draw your attention to the entry that is, it says 3209 under app lock, but we know that the 00 is a 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red. And this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us. He said device locked with lock button for the last time. Do you see that?
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. Do you know that?
Yes, sir.
Okay. And that is an interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be accurate as a digital forensic analyzer on the topic of the last of an indication of interaction with the device? Don't you think it would have been appropriate to look at that 12:32:09 in any of the tools you said you used on direct?
I did not correlate that artifact in my timeline.
I understand you didn't. And my question is, you make a statement. Well, let me back up. Do you understand that in this case, as in many cases, that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report, that from that point, 12/20/50, there is no indication of interaction with the device, is incorrect?
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
Is there anything that had prevented you from reviewing that in that data before you wrote this report?
Not that I can think of. I would have to go and re-review that.
My question is...
I don't know if that artifact, I have not reviewed that artifact, so I cannot speak to an artifact I have not reviewed, and I did not, that is not my report, that's Mr. Whiffen's report, so I cannot speak to that without going back and reviewing that evidence.
Isn't the interaction with the device, a lock button, readily available to you in the data that you have and had in your possession when you wrote this report?
Yes.
Thank you. if you could please turn to, in the same report, page 1528, which is your page number 6. And I just want you, please, to go to the, just put a placeholder in that. And if you can now just go to the conclusion, which is your page 50. Let me know when you're there.
I'm there.
So in the conclusion, you state that starting at 12:01 a.m. on January 29, 2022, the mobile phone was in use with activity of Waze navigating to 34 Fairview Drive, Canton, MA, active interaction with the screen, steps, audio playing text messages and calls until 12:31 a.m. EST on January 29, 2002. Did I read that correctly?
Yes.
That statement is also incorrect, isn't it?
On what basis? I
Do you believe that statement is correct or incorrect?
I believe that the statement is correct regarding those artifacts that are mentioned in that statement, yes.
Okay, if you could please, if you could turn to page 1535 of the same report.
Can you give me my page number, please?
I will. I'm
Okay,
just.
thank you.
You're welcome. If you could turn to your page 13.
13, Roger. Yes, I'm there.
And do you see an entry that says 12:31:56, which is the same time in the conclusion, but I'm going to develop it.
I believe I know where you're going.
Hold on. I'm sorry. I need to ask the
apologize.
questions.
Yes.
I appreciate you looking to help, but if I could, I'd appreciate it.
Absolutely.
Thank you. So it's got health steps, and it has steps 36, duration 20.9 or 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you look at this data point in your report on page 13, the steps began at 12:31:56, but they ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your statement in your conclusion, if you could go back to 50, and this is in your conclusion, your statement there is that the steps, the mobile phone is used with activity, including steps, until 12:31 a.m. EST. That should read until 12:32:16, correct?
It depends on your interpretation of interaction. As a user is walking, they're not actively interacting with their device. It's their movement that is. It's not direct interaction with the screen. But I would agree to your view that that could be interpreted as needing an additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken? Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand,
Yes.
but the sentence reads includes steps, and the more accurate way to have stated that would have been to put 12:32:16 instead of 12:31 a.m., correct?
I'm sorry, you just said 12:30. I did this to the minute, not to the second. Could you rephrase what you were stating?
Well, I'll state it again.
I appreciate that.
You're welcome. So isn't the more correct way to state this important data point in your conclusion, instead of saying active interaction with the screen and steps, etc., until 12:31 a.m. EST, the 12:31 should be 12:32, because the steps that you have on your page 13, by what you concede, is the duration of 20 would have brought it to 12:32:16, correct?
I would state that depends. I believe either is a correct way to state that. Based on interactivity, based on your interpretation, your definition is more correct.
Okay, thank you. And it's not my interpretation. I'm reading from your report, correct?
Your interpretation that 1232 is a more correct representation of interaction is based on your theory that interaction concludes when the steps end. And I'm saying both would be acceptable.
Okay, so let's follow up on this.
Sure.
Isn't it correct that it isn't my theory when the steps ended?
Oh, it's not,
if I could just finish,
Please, absolutely,
because if we
sorry.
talk over each other, the stenographer's not going to get both of us. Thank
Agreed.
you. So it's not my theory. It's just the simple math from an entry you've made on page 13 that the steps began at 12:31:56. They ended 20.398 seconds after that, which just doing the simple math is 12:32:16. Did I do the math correctly?
That is correct.
Okay,
I'm not
thank you.
debating that.
Thank you very much. So now what I'd like to do is to go to page 1528 of your report.
Do you have my page number for that? I'm sorry.
Yes, and I appreciate that you go page number. So I center in on the lower one, then I'll go immediately to the one. So it's your page 6, Ms. Hyde.
Thank you.
You're welcome. Just let me know when you're there.
I'm there.
If you could please go to Apple Health Data Steps.
Mm-hmm.
And we've been talking about steps because they're important enough that you put them in a report, correct?
That is correct.
So let's go to an important data point, therefore, in your report, in the chart, which is the second entry, which is, as you've stated, 12:21:10 a.m. Do you see that?
I do.
And you note under the data that John O'Keefe's phone registered 80 steps at 12:21:10. Did I read that correctly?
You did read that correctly.
And those 80 steps constituted 191.253 seconds, as you state, correct?
That is what is stored in that database, correct?
And is my math correct, so that the jury understands this perhaps a little better?
Sure.
That 191.253 seconds equals 3.2 minutes?
Approximately, yes.
Approximately.
I'm doing the math in my head, so that's why I said approximately.
Right. Understood. So am I reading this entry correct, that you're stating what the data shows, that 80 steps were taken by the phone of whomever had the phone of Mr. O'Keefe? There were 80 steps taken at 12:21:10 a.m. on January 29, 2022, for a length of time of 3.2 minutes.
That is what the phone registered.
That's what the phone registered. Very well. Now what I'd like to do is to turn to the phone of Jennifer McCabe.
Okay.
And that is, for your reports, you don't date your reports, so I can't give you a date, but it says...
It's report 3, I believe, is what you're looking at.
Exactly.
Yep.
It's 3. And there is... Bear with me, I'm accommodating your page reference, and I'll have it soon for you. It is your page 7. And let me know when you are there.
I am there.
Are you aware of an issue regarding the time of an interactive phone activity on Jennifer McCabe's phone at 5:07 a.m.? Are you aware of that issue, and particularly a communication to a person named Coco? Are you aware of that?
I would need to check in my report. May I turn to the page
Absolutely.
for that time?
And
I do
if it
see
is-
an outgoing call to someone labeled Coco at 5:07:21 a.m.
And you can tell that because in your report on page 11, you list a 5:07:21 a.m. call to a Coco as outgoing, correct?
Correct.
Have you discussed that call with any member of the Commonwealth?
No.
And again, this call is at 5:07 a.m. on January 29th of 2022, correct?
That is correct.
There is no duration listed for that call. And if you just follow my questions, if you can, yes or no, is that correct? There's no duration yet listed.
Correct.
So what I want to do is to also note that that omission is not the only omission of durations from this report, or I'll state it differently. Let me withdraw that. There is no population of the duration column for any call from 12:14:30 a.m. on January 29th, 2022, all the way through this 5:07:21 call. And you don't start listing durations until 8:59:34 a.m. Is that correct?
Yes, and explainable. The artifact.
I understand
Yes,
Mr.
okay.
Brennan can
Sure.
handle those on his redirect.
Absolutely.
So there's not a population of duration of calls after numerous early calls and phone, as you call it, interactive phone activity. Nothing populated in this report until 8:59:34. That's correct?
Yes.
All righty. Now what I'd like to do is to turn to the 22740 artifact that was the subject of much discussion on direct. And I am going to refer to that as an artifact. Is that a parlance that is familiar to you?
Yes.
And if I refer to that as a timestamp also, is that a parlance that's familiar to you?
Absolutely.
So I can refer to 22740 as a timestamp and you would find that parlance acceptable.
Yes.
Thank you. So I'm going to do that. Just to keep it simple, I'm going to refer to it as a timestamp. Now, you've been on this case working for the Commonwealth since May of 2023, correct?
May 4th, 2023. That is correct.
So you've been on this case for 2 years, correct?
Not actively the entire time.
But you started on this case in May 2023. You issued a report in May of 2023, correct?
Correct.
You issued a report in December of 2024, correct?
Correct, after being rehired in November.
Right. And you issued more reports in 2025, correct?
That is correct.
So all of that activity has been on this case, correct?
All on this case.
And that's been all on behalf of the prosecution, correct?
That is correct.
None of that work has been done on behalf of the defense, correct?
That is correct.
So let us now go to the timestamp of 22740. Your opinions on what is the meaning of that timestamp have varied from May of 2023 until today. Is that correct?
No, that is incorrect.
Let's cover that issue.
Sure.
Let's turn to your May 2023 report. Isn't it correct that the report and your findings were pursuant to a request from Detective Lieutenant Brian Tully?
Correct.
And how many interactions have you had with Lieutenant Detective Brian Tully on this case approximately?
I really don't know. I'd have to go look back at email and call logs.
Is it more than 5?
Yes.
Is it more than 10?
Yes.
Is it more than 20?
I don't know.
So somewhere between 10 and 20, would that be fair?
Again, I'd have to review my call logs. I'm not
But it
going to
was
test.
more than 10.
More than 10, I'm sure.
So the issue was your use of various forensic tools that revealed a timestamp, 2:27:40 a.m. timestamp on January 29, 2022. Is that correct? Is that a fair characterization of an issue you looked at?
Correct.
So if you could go to page 5 of that report. And I would ask that you go to the last paragraph that starts with "in the instance of the Google search," and let me know when you're there.
I'm there.
So it reads, "In the instance of the Google search, house long to die in cold, that was recovered from the write-ahead log associated with the X browser state DB SQLite database with the timestamp of 2:27:40 a.m. was marked by Celebrite as having this timestamp and being deleted." Did I read that correctly?
Fair. Yes.
So you use the words that Google search, "house long to die in cold," was associated with the timestamp of 2:27:40 a.m. Isn't that what your words are in this report?
In that database, they are associated. That is correct.
Right. And in terms of page 3, if you could go back, of your report, under relevant findings.
Mm-hmm.
It starts with, "There were 2 searches of interest that took place on the iOS device," and we're talking about Jennifer McCabe's device, correct?
The device that was identified to me as Jennifer McCabe's. Yes.
That's identified to you as Jennifer McCabe. And it's what you talked about on direct examination as her device,
Absolutely,
right?
yes.
It's not a mystery as to whose it is. It's not like you don't know, right?
In direct, I also use the phrase "identified to me as Jennifer McCabe's."
Right. But your conclusion is the device you've been working on and analyzing for 2 years is the device of Jennifer McCabe.
That is how it was identified to me.
Do you have a different conclusion as to whose device it is?
I always am very, very careful that I did not assess the ownership. That was information that was given to me, not information that I personally assessed.
So are you uncertain as to whether the device you've been working on for 2 years is the phone of Jennifer McCabe?
The device that I've been working on for 2 years is the device that was identified to me by the Massachusetts State Police, Detective Tolley, as belonging to Jennifer McCabe when I began working and received that device, as stated in the evidence analyzed section on this same page.
So let's go, and we're talking about, again, to get back to the center of gravity, we're talking about a timestamp of 2:27:40 a.m., correct?
That is correct.
And when you issued your first report in May of 2023, the timestamp you were looking at was 2:27:40 a.m., January 29, correct?
I was looking at multiple timestamps associated with the same 2 searches.
Right. So what I'd like to do, you said multiple timestamps. What times are in the multiple category?
What I was tasked to do was to look at the times, the search, the Google search history, I'm sorry, not Google search history, the Safari history, which includes Google searches, associated with those 2 search terms within that 12-hour period. That was the particular task, not the task of looking at the 2:27, just for clarity.
Right. And I appreciate that, but my question wasn't that. My question was, I thought I heard you on direct examination, which is why I repeated the question, what I thought I heard on direct, but I'll ask you the question.
Sure.
You looked at and talked about on direct 2 potential times for a Safari search, which includes Google, one of which was 2:27:40 and the other one was 6:23 a.m. Is that correct?
I analyzed the meaning of those 2 timestamps.
Right. So we're just talking about 2 times, 2:27:40 and then 6:23. Is that correct?
So you are only talking then about the one that we're also talking about 6:24 a.m.
Okay, so we
Eastern
got
time for clarity, because some of these records are in UTC, some are in local.
fair enough. So you've got 2:27:40, you've got 6:23, and you got 6:24 that you were looking at, correct?
There are other timestamps that exist in the realm of what I was looking at, but those ones, correct, are the ones that are relevant in this report.
Exactly. And that's what we're talking about.
Okay,
We're just talking about this report.
Yes.
And so if you look under relevant findings, at the very bottom paragraph, you say, second sentence, a Google search for how long to die in cold at approximately 11:23 a.m. and then how long TIDIE in cold took place at 11:24.
That is in UTC. I apologize for not having the timestamp format there, but that is the UTC time. The UTC time equivalent in Eastern Local Time would be 6:23 and 6:24.
So to be clear, in your report, you wrote 11:23 a.m. and 11:24, and you didn't put UTC next
Correct.
to it, did
They
you?
should. You are correct. That should say UTC. That is a typo.
And there's a significant difference between 11:23 and 2:27:40, correct?
11:23 is UTC, so its equivalent in Eastern Time would be 6:23. The artifact of 2:27 is already in local time, so that is in Eastern Time. So what we would be comparing is 2:27 and 6:23 and 6:24 to be appropriate. They're taking into account the data storage and which ones are in UTC and which ones are in local time.
I understand your explanation now.
Perfect.
But in this report, there is no UTC time down. You have two additional times in addition to the 2 times, 2 different numbers added to the 2, correct?
The UTC was a typo. It should say UTC next to those. And the chart shows all of those artifacts in EST and is clearly labeled that they're all in EST.
So you would agree that it's better stated to state it a different way than you have in your report?
I would say that both are equivalent. I should have had UTC there. But yes, it's easier for the audience to speak in EST. I would say forensics examiners typically communicate in UTC, but we translate for our reports. And I should have either communicated that in EST or included UTC. I will definitely contend that.
So in terms of your May 2023 report, your first report in this matter.
Yes.
You on page 5, in the sentence underneath the block paragraph state, in the instance of the Google search, how long to die in cold that was recovered from the write-ahead log associated with.
That's correct.
The X browser state with a timestamp of 2027:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
You read that correctly.
Now let's move ahead to page 7 of your report. Up at the top above conclusion. Importantly, at this time, you state, testing shows great inconsistency with timestamps parsed from this file. It is, however, definitive that the page existed in a tab.
Correct.
While a definitive reason as to why the timestamp is listing the time of 2:27:40 is unknown, the time is inconsistent with the timestamps associated with the same search. Did I read that correctly?
You did read it correctly.
So as of May 2023, you said the definitive reason as to why the timestamp is listed as 2:27:40 is unknown, correct? I'm just asking, is that what you wrote? Unknown.
I believe that the wording here is, sorry, I know I do use the word unknown. It says, while a definitive reason as to why the timestamp listing is the time of 02/27/40 is unknown. Sorry.
So you use the word unknown, your word in your report.
Yes.
Okay, so now what I'd like to do is to go on to the first proceeding in this matter. Do you remember giving testimony in a proceeding about a year ago under oath?
Yes, I do.
I am now going to go to that testimony, and if at any point you would like to have a copy of that, if it's the honor, if your honor would like, I will do it, but I'm going to start and then we'll see how it goes. So bear with me a moment. Do you recall in that testimony stating that you processed the image in several forensic tools? I use Celebrite Physical Analyzer, and then you list many other tools. You remember giving that testimony?
We have a page.
I'm sorry, Mr. Brennan, I thought I'd given it 1-12. My apologies if I didn't. It's June 14, 2024, page 1-12. You're welcome. So do you recall giving testimony about the various tools you use for this timestamp?
I do.
And do you recall stating that those tools were commonly used digital forensic tools that are very standard? Do you recall that?
I'd have to see the wording that I used at that exact time.
Would it be helpful to refresh your recollection if I showed you that?
It would be great. I would greatly appreciate that because I do not recall the precise wording, but I know that I spoke to the tools I used.
May I approach, Your Honor?
Yes, Mr. Alessi, you offered a transcript. Do you have the whole
I have
transcript?
the whole transcript if that helps.
It might speed things along.
Agreed.
Okay.
We have one out provided. Ms. Hyde, I'm going to give you a transcript.
Thank you. I appreciate it.
So, may I approach, Your Honor?
Yes.
Thank you. Mr. Brennan?
112. You are. That's, let me turn it over to, it's going to be 112.
Okay.
Yep. You're welcome.
Thank you so much. And you said we're on 112?
Yes, please.
113, I see it. I see it's highlighted on the copy, so I
Right,
figured
so
that's the
what I
one.
wanted to do, the reason I said 112 is that's where I started with my
sorry.
previous question. So I'm not going to repeat the question, but just to orient you, so you have a fair context for the questioning.
Fair.
So I started at the bottom, 112, now I'm moving to 113, and I'm starting with line 7. Do you see that?
I do.
And it says, yes, they are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. Did I read that correctly?
That is correct.
And then if you go down to line 22, you testified in that proceeding. So it's important to use multiple tools so you can see the results from different data sets, and be able to compare those results and enhance those with manual analysis. Did I read that correctly?
You did. That's correct.
And then going up to page 114, line 5.
Slow down a little bit, Mr. Alessi.
I will, Your Honor. Thank you. Yeah, that's very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretation from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent to that. Did I read that correctly?
That is correct.
And then lastly, for this section at page 114, 17, the Sanderson tool is meant to look at specific type of data structures called the SQLite database. XQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Did I read that correctly?
Yes, you did.
Thank you. Now, if we can go to page 124 of the very same testimony. And feel free to go back a page just so you can see to page 123 that the topic is the 2/27/40 timestamp associated with house long to die in cold. Do you
Can I
see-
have a moment just to review and get context?
Absolutely.
Thank you so much.
Page 123:13, but if you need to go back further, feel free.
Okay, I'm good. Thank you.
You're welcome. So what I want to do is start with page 1-23, and this is your testimony. On line 16, I have them in the timestamp order that is associated with the artifact. You use that word associated again, correct? Did I read that correctly?
Yes.
And that's associated with the Google search house long to die in cold in a 2:27:40 a.m. timestamp, correct?
That is correct.
Now, if you turn the page of the testimony, you state back then that on page 124, line 1, the browser state DB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that the tab moved. It could be lots of things. Did I read that correctly?
You did.
Not one thing. You said it could be lots of things, correct?
That is correct.
And then you go on in line 10 and you talk more, and then you go down to the bottom. You go down to line 20 and you testified, we cannot tell by this particular artifact what time that search occurred. Did I read that correctly?
It's specifically pertaining to that particular artifact that give in browser state DB. That does not tell us what time a search occurred. That is correct.
Right. So you stated, and it was your statement then, we cannot tell by this particular artifact what time that search occurred, correct?
That particular artifact.
Okay, so now let's keep going. If you go to page 129 of this transcript,
I'm there.
at the top,
Sure.
line 1, 2:27 isn't necessarily one time when the tab was closed. That's in my report. I say it's undetermined. Remember, we were just reading your undetermined
Absolutely.
in your May 23 report?
Correct.
Because there's a lot of things that can cause that timestamp to be there, including tab being moved, tab being minimized. The next sentence. I don't know exactly what caused the tab to get that particular entry, but it's not, that timestamp is not indicative of the time of the search or any URL that's visited. But the first part of it is, I don't know exactly what caused the tab to get that particular entry. Did I read that correctly?
You read 100% correctly.
Thank you. Now, if we could turn to page 130 of your testimony.
I need to object.
Right. I'll see you both.
Oh my God.
Dude.
Brutal.
Fact, somebody fed me after midnight. Isn't it a fact it might have been some kind of medication I shouldn't be on? Holy shit. Dude.
This is like just cherry picking parts of her testimony and report. You can tell she's itching to explain too.
I know
Yeah.
he won't let her.
Big time.
He won't let her respond. I mean, the first one though, I'm like confused about like because it says 12:20, right? Was the last interaction, so it'll be. I mean, she'll get redirected and explain it, but everything else seems like total BS. Like you didn't put UTC, but in the chart it's in Eastern time, so
Right.
shut the fuck up. Like,
Did you or did
he's
you
like,
not make a typo? Like, oh my god.
Hey,
yeah,
Kate, I
parsing
think
words.
somebody else is backstage there. Take a peek.
Oh, yep, she's here.
Yeah. Right on.
I am dying with this one.
Yeah.
He's treating her like she is 5, and she's actually kind of treating him the same way back. This is the
Yeah.
weirdest
I
cross
know.
and redirect I've ever seen.
I could see the Free County crew just kind of like getting extra upset. Like, how dare she? Because they're probably used to hearing that a lot from pretty much everybody they come across in life. You know what I mean? Like, oh, it's a trigger. It's triggering. It's how everyone talks to me because I'm a fucking dummy. Like,
I
God.
know. She's like, good job. You read that correct. You were good
Yeah,
job.
absolutely.
Good job,
Yeah.
idiot.
And then he comes back with loud noises. Like, what the hell was that, too? Like, most of his questioning was him yelling like a
Matt,
like
you
a
have
maniac.
a parody where she's 5 and he's 5.
God
Go
damn.
AI and make them look like little kids, or it's just so ridiculous. And I say that with her only because she's looking at him like, yes, that's correct, because
Because she really wants to speak, and
she
he's
knows
not
what
letting
it
her.
means, and he doesn't.
She's looking at him like a kid would at an orangutan with poop on its hands. You know what I mean? Like, what the hell am I looking at? This is a freak show. She's got to be beside herself.
I feel like
wondering what
she's
that
speaking
is.
to him like she's an elementary school teacher. That was the vibe that I got.
Yeah,
Yeah,
maybe
I got that
better.
too. No, she's an educator, right? So, I mean, when you come across people that are trying to learn, you kind of gauge where they're coming from, what their limitations may be. And sometimes there's that moment where you kind of, okay, this student is challenged, and there's no other way, but you kind of like naturally just want to click into, talking the way she is. Like, good for you, champ. I mean, it's a natural reaction to somebody who's confusing you like that. I mean, I don't think she expected a lawyer to be that derpy, but here we are.
I think the most shocking part of Alessi's cross this far for me is when he was pressing her on writing that the last interaction with the phone was at 12:31 and not 12:32, just because he yet again highlighted like, well, at 12:32 he took 36 steps over 20 seconds and that was the last time. Like, why are you highlighting the last time that this guy moved? Like, why would you do that? I thought you were working for the defense.
And again, another instance where we're questioning, are they trying to do damage to your own defense? It makes no sense.
Thank you for your patience, Ms. Hyde.
Absolutely, sir.
What I'd like to do is to go back to your testimony in the first proceeding, and we can go back to page 1-30.
I am there.
Thank you. So I am going to go back just because there's been some time and give some context. So we're talking about the 2:27:40 a.m. timestamp, correct, at this page location?
We've been talking about that for several pages. Yes, that's correct.
You're absolutely correct. We've been talking about it for several pages. And bear with me, I think this may be either the second to last or the last. So there you testified with regard, this was when you're referring to an artifact. You've agreed that timestamp is a fair synonym. You say on line 5, that means it wasn't in the regular database. It was in the write-ahead log. And to Celebrite's credit, that tool actually parsed the write-ahead log and displayed it where the other tools did not. So did I read that correctly, number one?
You read it correctly.
So am I correct that here what you're stating is Celebrite was actually showing the 2:27:40 a.m. timestamp at that time during your testimony in the first
on
proceeding?
that date, That is correct.
Okay,
Yes.
so I just wanted to establish that, and you were
Absolutely.
giving Celebrite credit for actually showing that timestamp at that time of 2/27/40 at the time of your testimony back in June of 2024, correct?
That is correct.
Okay, so now let's go to page 1-36.
136, you said?
136, yes.
Thank you.
And on line 12, you note that so Celebrite and magnet axiom,
Mhm.
and then you elaborate both Celebrite physical analyzer, which is a specific tool, right, of
Correct.
Celebrite, and magnet axiom, another specific tool, correct?
Correct.
Both have file system viewers that then have SQLite database viewers. And you skipping down to line 17, you talk about they don't allow for deep analysis of the write-ahead logs, which is why in my analysis I use the specialized Sanderson forensic browser for SQLite, correct? I read
That is correct.
So is it fair to say that what you did up to this point in June of 2024, with regard to the 2/27/40 a.m. timestamp on January 29, 2022, you applied a variety of tools to analyze the issue of when did the Google search occur, that you use the words associated with a Safari Google search, house long to die in the cold?
There's a little bit of wording I would correct there if that's okay.
Right, but so let me see if I can ask the question
That'd be
a
great.
different, more simple way.
Thank you.
You're welcome. So you used a variety of tools to analyze that house long to die in the cold search, correct?
Plus manual analysis and testing. Yes.
Plus manual analysis and testing. Alrighty, now let's leave the testimony.
Okay.
And let's go to your next report. And your next report is December 2024. Do I have,
I have
the
it correct.
chronology correct, Ms.
That
Hyde?
is correct.
So in December of 2024,
Mhm.
just approximately 6 months ago, you issued another report, correct?
That is correct.
And you got the request for that report also from the Norfolk District Attorneys, correct?
That is correct.
And you state in regard, well, that report regarded the analysis of the same timestamp, correct?
Correct.
To 2/27/40 timestamp.
Mhm.
And in that report, under relevant findings, you state, and this is December of 2024, so it's from your May 2023 report, it's approximately a year and a year and a half. Is that approximately from your May 23rd report? Approximately a year and a half?
Yes.
So a year and a half after what we just reviewed in your May 23rd report, and then just months after the testimony of June, right? So about 6 months after your
6 months later.
June testimony that we just went through, you went and looked at this issue again, correct?
That is correct.
And isn't it correct that when you were asked to look at the same timestamp in December of 2024, that Celebrite removed the timestamp from their tools?
Celebrite did remove that timestamp from the tool. That is correct.
Okay. And that timestamp was the subject of extensive reports and testimony that you participated in the first proceeding, correct?
That is correct.
And even though that timestamp, 2/27/40 a.m., that showed up in Celebrite tools, Magnet Forensic Axiom showed up, that was removed by Celebrate, correct?
Celebrite no longer reports it. The evidence is still in the data. I want to be clear, just that it doesn't change the data. They just removed it from their automated parsing and reporting.
Right, so they
Correct.
removed it from their automated parsing and reporting.
Yes,
correct?
they did. That is correct.
However, your former company, Magnet Forensic Axiom, still shows it.
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that and gives a description in their artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
Magnet Axiom Forensics, where you used to be the director of forensics.
That is correct.
Still shows that timestamp.
Yes, yes,
But Celebrite doesn't in the
that
automated
is correct.
tools.
That is correct in their automated parsing.
And you would agree that Magnet Forensics is a very reputable company, correct?
Correct.
Let's go back to your December 2024 report. Do you recall just moments ago when we went through your testimony in June of 2024 in the first proceeding where you stated various times how it was, I'll use the term best practices, to use multiple tools to analyze the timestamp?
Correct.
And you used many tools back then to analyze that timestamp. And you testified to those many tools on your direct examination, correct?
Correct. Yes.
However, in December of 2024, when you returned to analyze the 22740 timestamp, how many tools did you use to analyze that timestamp? Can you give me just a number? How many tools?
At least 4.
Well, in your report, let's go to your report, what your report says.
Mm-hmm.
So in your report, you state that under relevant findings, do you not, that review of data from Celebrite shows that the artifact of a Google search from a Safari suspended state tab with the search term house long to die and cold, and I'm going to skip over, in addition to my own previous report, no longer shows a last visited timestamp.
I think that is not clear. The skipping there makes it sound like my report no longer shows that, and that's not what's
That's a fair statement. That's a fair statement. Let me rephrase it.
Thank you.
Way. You're welcome. In this report, you speak about Celebrite release reports, correct?
Are you referring to the Celebrate release notes
The
that come out?
release notes at the bottom,
Perfect.
right? You referred to that?
That's correct.
And that release note states that Celebrite has removed the timestamp value from records, and I'm assuming that's a reference to Celebrite's.
Celebrite no longer parses that result. That is the statement in this report. Correct.
Right. And so I'm going to go to page 4 of your report.
For sure. I'm there.
And I'm going to go down all the way down to the conclusion. In that report, is there reference to any company other than Celebrite in this entire report?
In this report, no.
Okay, thank you. Now let's go to your prior testimony in the first proceeding, where you said that it was important to use multiple tools.
Absolutely.
Do you still stand by your position that you've given today and that you gave in June, that it's important to use multiple tools?
Absolutely.
Now let's go back to the issue of the extraction of Jen McCabe's phone. And what I want to do is to cover a concept and see if I've got this correctly. Are you familiar with the phrase Apple source codes?
I'm sorry, can you please repeat?
No worries, sir. Are you familiar with the phrase Apple source codes?
Apple's source code? Absolutely, yes.
And isn't it a fact that Apple keeps its source codes proprietary, meaning very few people have access to it?
That's correct. It is closed source is the term we would use.
Closed source.
That would be the term of art, correct?
And they keep it so close that they call it closed source.
And it's not just Apple. Lots of tools are closed source. That just means that the code isn't available like it would be for the tool I mentioned earlier, iLeap. That's an open source tool. Anyone can look at the code. For Apple, we cannot go look at the code that makes your phone run. That's correct.
And isn't it the case, and I refer to that as the MB postulate, to shorthand it, but I don't need to have you refer to it that way.
I'm sorry, could you repeat that phrase? I was unfamiliar with it.
I'm going to skip it.
Okay,
I'll
thank
just
you.
go on. Basically, the concept that Apple has source. Wouldn't the best information about when a search occurred, what it's associated with, wouldn't the best information be in the Apple source code to answer that question?
It is acceptable in digital forensic science and in accordance with the NIST Science Foundation papers to conduct testing to determine how the functionality of something works. You do not need access to the source code to be able to speak to an artifact.
My question isn't that. My question is, isn't the best place to go is to the Apple source codes themselves? Or are you saying these physical analyzer tools are just as good, and the information they pull is just as good as an Apple source code?
Those are very, those are incongruent statements. Apple source code is not a healthy way to do an examination because it would be so onerous, and we do not know the level of documentation. We don't know the language. That is not necessarily the most effective way to determine what data is. Forensics tools parse results of how data is. They don't interpret them. The examiner interprets them and provides meaning. And I would like to state that those three things should not be conflated. They are very individual concepts.
I think you misunderstood my question.
I probably did it because that's what I was seeing.
My question is this. Isn't the best source for information about data in an iPhone contained within Apple source codes?
Not necessarily. Because that doesn't perform, operational performance is a better source in a practical sense to being able to determine what something is, as opposed to zillions, and no, I don't know the number because it's closed source, lines of code that may or may not have different levels of documentation. Apple themselves wouldn't be able to, any individual there who has access wouldn't know every feature of how every element works. Testing through the methodologies described in NIST is the accepted methodology in our science, not reviewing the source code.
I'm going to try it a different way. I understand what you're saying is, if I got it correct, you correct me. Are you saying that these physical tools make it easier to interpret and view the data?
I did not speak about the tools at all in the statement I just made.
Okay.
I spoke about manual testing and checking the functionality and what results. Parse tools, again, these are three separate concepts. The concept of code and actually reviewing code to make a determination is different from parse tool results, is different from doing testing and validation. Those are separate concepts. They should not be commingled as if they equate to each other.
So have you ever spoken with Mr. Whiffen?
I have spoken with Mr. Whiffen historically, but not since the term of this trial.
Okay. Have you ever spoken to Mr. Whiffen about whether the Apple source codes are the best source of information about topics like timestamps? Have you ever spoken? That's just a
I have
question.
not had
Have
that
you ever talked to him?
conversation with Mr. Whiffen, no.
Okay, all right. I want to move on to, and do you regard Mr. Whiffen is a reputable?
Mr. Whiffen is a reputable forensics examiner, and I've actually reviewed his work in other instances and peer reviewed his papers.
So you have regard for his
I have
reputation?
regard for his
I'm sorry,
reputation.
we have to wait for each other.
Oh,
to
yes,
talk
I'm
through the
sorry.
It's all right, no worries. So you have regard for the opinions of Mr. Whiffen generally, correct?
Absolutely, yes.
And you believe he has a solid reputation, correct?
Absolutely, that is correct.
Now let's turn to the History DB database. You are familiar with History DB? History DB, are you familiar with that phrase?
I am familiar with that phrase.
Okay. Do any of the house-long searches appear in the History DB?
In this instance, no, we do not have artifacts in the history DB of either of those two searches.
So I want to just repeat that in a different way. So the History DB, is that considered a valid and valuable source of information in an iPhone?
That is a valuable artifact for Safari history. That is correct.
But the house-long searches we've been discussing do not appear in that History DB, do they?
That is correct.
You spoke about PYF PDF on your direct testimony. Do you recall that?
I do. It's the Python framework for PDF. It is a GitHub tool, one can download from GitHub to utilize to create PDFs using Python code. So a developer and a tool would integrate that to create a PDF.
And the PYF PDF can have the variables set, correct?
Yes, the Python script allows the developer to set things such as their name that they created the document. Yes.
I want to go to the extraction of Jen McCabe's phone that you talked about on direct examination. Is the hash value signed or unsigned?
A hash value isn't signed. I believe your question you're asking me is if the Adobe document that contained the PDF that contained the hash values, are you asking me if that's signed? Because a hash value is something that matches. A hash value isn't signed.
Let me ask it this way. Is there any hash value associated with Jen McCabe's phone that is unsigned?
That is not a valid question. I apologize. We don't refer to hash values as being signed or unsigned. We would refer to the PDF that contains that value as being signed or unsigned.
Have you ever read a report of Mr. Ian Whiffen in this case?
I have, but I have to be clear. I have not read all of Ian's reports. I've only read some, so I don't know if I read some of his earlier reports.
Do you recall reading a report of Mr. Whiffen where he references a hash value being unsigned associated with the iPhone of Jennifer McCabe?
Can I see said report so I can validate if I did or did not? I'm not sure based on just that, because I wouldn't use the term hash value being signed. I did see a report in which Mr. Whiffen spoke to the PDF not being signed.
I just want to try to shortcut this and work off your last statement. You're now saying you do recall seeing a report of Mr. Whiffen where he said a PDF was unsigned?
I need to see, I do remember him referencing the PDF. I would need to see the report, especially since the characterization of hash value being unsigned is not a term of art that I am familiar with in our field.
Let me ask if you agree or disagree with this statement. This value can be used to compare with the original hash calculated at the time of extraction in order to validate the extraction data. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%. Do you agree or disagree with
His
that
statement there says the PDF is unsigned, not that the hash value is unsigned.
Right, but it's nonetheless unsigned, correct?
The PDF is not signed. That is a correct statement. Gray key PDFs that purport that value are not an Adobe signed document.
Do you know the history of the extraction of Jen McCabe's phone? It's a yes or no.
Can you provide more clarity? What do you mean? Do you mean from the time the image was made? Do you mean from the time the device was received? Because I don't know the information pertaining to the receipt of the device into evidence, and then I only have the documentation of the image forward. So I want to be clear about what period we're talking about.
It's an excellent point, and I am going to follow up with some questions.
Okay.
In an extraction, doesn't the extraction from a phone start with the raw data, raw image? You tell me, when someone brings a phone in, what's the first step that gets taken in order to do a full file extraction? What's the first step?
It depends. There's got to be steps with regard to network isolation. I need to know if the device is AFU or BFU at that point. So I don't have that information from this case, if that is the question. I get from the image forward.
So what I'd like to do, and this may be my last section of questioning, I'd like you to describe the ideal situation as to getting the most reliable data from an iPhone from the start. What's the most reliable way to do it?
I would say the most reliable way is following the recently released SWIG-DE Scientific Working Group on Digital Evidence document on best practices of evidence handling, preservation, and imaging. I may have that title slightly out of order, but it is the document released this January.
And tell me what that is.
Sure. In that, the first thing, from which point are we starting? Are we starting like extracting the data using a tool, or are we talking on scene, taking the device into evidence?
The latter.
Okay. So the first thing you're going to do is you're going to ensure that you are isolating the device. This is also going to depend on condition from the network. So typically this would be done with a Faraday enclosure in a best practice. However, there are alternative ways of isolating from the network, such as disabling all of the communication protocols, such as Wi-Fi, airplane mode, etc. The next step, once you've isolated, but prior to, you also want to make sure you're continuing battery stat. So if a device is on, you want to keep it powered on. If it's off, you want to keep it powered off. That's a general statement. So the best way to do that is to attach a battery charger. Just like when your battery runs low, you plug in a charger in the back of these battery packs. We do that with that before we put it in the Faraday bag. A Faraday bag is an enclosure that blocks signals from coming to the device. This is so a remote wipe command couldn't be sent, or so that more data isn't received to the phone, because phones are live and constantly obtaining data. So we're going to have it with a battery pack in the Faraday, presuming it was on. Again, I don't know the status of this device. The next steps are going to depend on what state that device is, and what make and model that device is, and what the current support for that device is. There are multiple types of extraction methods of phones. In the modern day on iOS, a full file system image, what we had on the devices in question in this case, is considered the gold standard because it has the most robust information. So at this point, the next question is what's the best image type? And that's going to depend on if we have a passcode or if we don't have a passcode.
If I could,
please.
And I'm going to allow you to continue.
Yeah, please.
I want to break it down for the jury. So what I now want to do, you've stopped at a certain point, but you've talked about securing, what I would call securing the phone, right? And then making sure that there's no data swipes. You talked about airplane mode, Faraday bag, Faraday box, right? Do you know whether any of those protocols were followed for either the iPhone of Jen McCabe or John O'Keefe?
As I mentioned, I was not there for those processes. I don't have documentation of it. As mentioned, what started where my receipt of the device is from the image.
Exactly. So you don't know.
I can't testify to processes I did not or was not available or aware of.
Fair enough. But do you have a little bit of hint as to whether the phone of Mr. John O'Keefe was properly secured in airplane mode, a Faraday bag, or a Faraday box, based upon your own report of the iPhone of John McCabe? Can you determine that from page 5 of your report?
Obviously, there is data signals that are still being made and created. I believe that is what you're referring to. So the assumption is that I don't know at which point a Faraday bag is employed, but I also want to be clear, I don't know when, I don't have information outside of the digital forensics realm about this case, so I don't know precisely when the phone was taken into custody by law enforcement.
Fair enough. So assume that Mr. O'Keefe was deceased around the latest 9 a.m. on January 29th, 2022. Isn't there activity on that phone, health data activity, up to around noon of January 29th?
Health data activity would continue to be reported regardless of if the device was isolated from the network or not. Health data has to do with the movement of the device. So if the device was being moved even within a Faraday bag, that data would still be populated.
How about location data?
Location data is unlikely to be reported in a device that is Faraday enclosed, but I do not know what location data you're referring to, so I cannot speak in absolutes without having a better reference to the artifacts in question. If you're saying it's in my report, I'll look at it, but again, I never knew when the phone was seized, so it was not part of my initial analysis. Do I have permission to look at that time now? Yes. Thank you, Your Honor. So bear with me, it's a big report, as you know.
It is a big report.
And it was at the bottom of my stack.
Pardon me?
All right, it was at the bottom of my stack. I had to lift up the other ones to find it. All right, so.
Your Honor, may I assist and point her to a page?
Sure. That'd be
Thank
great.
you. If you could turn to that report on your page 47 and continue on to page 50.
I do see incoming data that is consistent with the device not being Faradayed, such as the receipt of SMS messages, notifications from Ring, etc.
So, the iPhone of Mr. O'Keefe was not secured in the manner you described before we got to this, as would be the best practice with regard to getting the most accurate data from a phone. That is, once it comes in, that it's to either be put in airplane mode, Faraday bag, or Faraday box. That's correct. By your own report, you see activity.
I do see activity. It was not Faradayed. Faraday prevents wiping of the device and additional data. So actually, in this instance, it doesn't appear that the device was at risk of wipe because it was not wiped. And we actually have more data because we get to see the data that continued to come into the device. I'm not saying that's in accordance with best practice. I'm saying that that's what I see based off of what you just had me review in the data.
It sounds like you're trying to justify.
Oh, I'm not trying to
right or
justify.
wrong, you tell me. It sounds like you're trying to justify the fact it wasn't secured. Am I correct? Or
No, you're incorrect. I'm just stating we have, you asked if we had more data or less data. We actually have more data with it not being Faradayed, but no, best practice would be to Faraday.
That
I
wasn't my
100%
question.
agree.
My question wasn't, is there more or less data? My question was simply, doesn't your own report show activity up until noon on January 29, 2022?
Correct. And for clarity, my scope was till noon, so I don't know if there was activity beyond that.
Right, but as far as your scope goes, I want to be clear.
Yep.
There is activity on
Absolutely.
this phone.
Absolutely.
Which shows that it was not put in airplane mode, it was not put in a Faraday bag, and it was not put in a Faraday box. And that failure is not best practice.
Correct. It is not in accordance with the best practices. I agree. I would have Faradayed it.
Thank you. So
If I,
that's
presuming
that's
all
okay.
things.
I have no further questions. Thank you for answering my questions, Ms. Hyde.
Thank you for your questions. Have a great day.
That's Renee, redirect.
Thank you. Of course.
Whenever you're ready.
Thank you, Mr. Gray.
You're welcome. You were asked when you began working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023, May 4th, 2023 is the email I have of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
When you first were asked to begin work on this case in May of 2023, what was the catalyst for you to begin working on this?
I was contacted by Mr. Tully and then contracted, a SOW was signed, and I began work on the initial request to look at those two search terms on January 29th. Does that answer your question?
Sure.
Okay.
Was there a certain claim that was lodged that you were to focus on?
I was to focus on the two search terms from January 29th, 2022.
And when you informed why, was there any context to that?
Probably, I don't recall the exact conversation that I had with the DA's office and Lieutenant Tully at that time, but I'm assuming that I was given that context. I have in my notes that I was to look at those two searches on that date and do an analysis about those.
Were you asked to reach any particular result?
No, I was asked to provide my report, not to reach a particular result.
Were you asked to reach a conclusion that the 227 timestamp was inaccurate?
No.
When you engaged in your analysis, was it independent of the district attorney's office?
My analysis was independent of the district attorney's office. I actually, in the first case, had very little communication with the district attorney's office during the period of my analysis.
Was there any input from any outside source on what your result or ultimate opinions would be?
No.
Would you ever allow anybody to affect your input?
No.
Throughout the course of your efforts with this phone, have there been changes to software?
Absolutely. As mentioned on direct, software updates are near monthly.
I want to ask you about changes to the Celebrite software. You were asked about certain reports you wrote. Were the reports that you wrote relative to different requests for analysis?
Yes.
The report regarding report number 3, regarding changes to Celebrite software, was that report limited to the timestamp change, or was it to include other efforts?
The scope of that report, may I review what I have documented as the
Please.
scope? I believe we're talking about report 2. That's the one about the Celebrate change.
Yes.
And I have the request was to understand changes made in the newer version of Celebrate Physical Analyzer to artifacts pertaining to the timeline of a particular Google search on January 29, 2022, namely how's long to die in cold.
When you looked at the Celebrite software and report, was the timestamp characterization changed or removed?
Yes, it was removed. That timestamp in the version starting in May of 2024, Celebrate actually removed that, and they put a release note stating that it was due to the ambiguity and potential for misconstruing the meaning of that data.
Was there any other releases informing other reasons why that was changed other than the potential that somebody could misconstrue, misinterpret, or distort the information?
Can I read Celebrite's own statement?
Please.
Celebrite's statement in
To yourself.
to myself? Okay, roger that. Thank you. I appreciate that. Can you
Could
repeat the
share with
question?
us,
Em?
was there any reason other than the concern about misinterpreting or
They
distorting?
said that
So what's your understanding?
my understanding is that it is not a reliable timestamp, and that is why Celebrite removed it.
You were asked about Axiom. Axiom, is it the same or different?
Magnet Axiom and Celebrite Physical Analyzer are two different tools that both do forensic analysis of mobile phones.
You were asked whether Axiom still has a timestamp that was similar to Celebrite before the change.
Axiom shows what I spoke to on direct, where they have it as a parsed versus carved result. And so that particular result shows in the suspended StateDB artifact as carved.
Do companies like Axiom and Celebrite give releases, updates, information about how to interpret their reports?
So Axiom actually has a document that's released with it called the Artifact Reference Guide. And that actually gives a brief description of the fields and of artifacts. All tools, when they release new artifacts, they put out in a release notes. Not all artifacts are clearly documented that are parsed. However, all of the vendors regularly put out webinars and blog posts that explain their new artifacts, but not necessarily all.
Is there any releases or cautions from Axiom on the same issue about misinterpreting a timestamp?
Axiom, in their artifact reference guide for this artifact, does speak to the possibility of misinterpretation and states that the timestamp can be earlier than the search had occurred, based on what different reasons could cause that timestamp.
Let me ask you about a Faraday bag. You said that best practices is to isolate an item in a Faraday bag.
That's correct.
Do you have any information, or did you know the travel of Mr. O'Keefe's phone that night, or where it went after?
I'm sorry, can you clarify the time period?
On January 29, 2022, from say 6:04 in the morning until later that afternoon.
I did not have access to that information.
When you analyze data from certain devices, are they always placed in a Faraday bag immediately after an incident?
There's a lot of times when this is situation dependent. An example of when you would not put something in a Faraday bag is when you have a deceased victim and you're going to be using their biometrics to possibly unlock the device. Because a Faraday bag is enclosed and then can't be opened, if your intent, if you don't have the password, is to use a deceased person's fingerprint to unlock the phone, we don't want to put the person's finger in the Faraday bag. So usually those phones would not be Faradayed, but they would typically have airplane mode enabled or SIM card removed. But no, SIM card removed doesn't actually work on iOS, so I won't get into that.
Understanding or having the opinion that this item was not placed in a Faraday bag at 6:04 in the morning, does that in any way affect your opinions about the data that you analyzed on this phone and the conclusions that you reached regarding Mr. O'Keefe's phone?
It does not have any impact on the conclusions other than the fact that it wasn't Faradayed and more data came in. So we have additional data.
You were asked a very specific question about History DB, and it was simply whether or not How's Long to Die in Cold, whether it appeared in History DB. That isolated question, does that provide any context for you and your analysis and conclusions about How Long to Die in Cold and that it occurred at 6:23 and 6:24 the next morning?
The absence of the History DB artifact doesn't mean that that search didn't occur at that time. We have multiple corroborating artifacts, which is usually what we look for, 2 artifacts that demonstrate is like very good. You don't necessarily need that, but in this instance, we have both from the Mobile Safari plist, which tracks the history, as well as the Knowledge CDB. So we do have 2 artifacts showing that those searches were done at that time. Of course, 6 seconds apart for the difference between a knowledge C and the mobile Safari P list.
On direct examination, you were not asked questions about Mr. O'Keefe's phone.
That is
but
correct.
You were on cross-examination, so let me follow up. You have a report that you authored regarding Mr. O'Keefe's phone,
That is correct.
and you had an opportunity to look at the healthcare data for January 29, 2022.
That is correct.
Page 6 of your report.
Thank you.
You noted that there were steps that began at 12:11:09 a.m. Is that accurate?
That is accurate.
And the way healthcare data works, do you have an understanding whether steps means a person actually took a number of steps, or does it mean something else?
Steps doesn't necessarily mean that you took a number of steps. It's based on the motion of the device. So it could be steps. It could be you're carrying it. It could be that you're in some other kind of motion. You could be on a bicycle. You could any number of things. And the number of steps is based on the presumed gait, based on the input into the Apple Health app in terms of gender and height. So it determines a gait and then prescribes a number of steps, but it is possible for other things to cause steps to occur.
You were asked specifically if you saw that there were reported movement or health steps at 12:21:10 a.m. and specifically pointed out to you notation or characterization of 80 steps. Is that accurate?
That is what's stored in the database. I try to clarify, as I did for you, sir, that that's what's stored in the database. I'm not saying that 80 steps were taken.
And by the way, in addition to the healthcare analysis, you did some analysis on the movement of a car, didn't you?
For Ms.
I'm going to deny that question.
Can these health steps occur if somebody's holding a phone while traveling in a car?
As mentioned in my report, it's caused by motion. It could be various motions that could cause it. You could be using an elliptical. You could be in a vehicle. You could be on a bicycle. It's not necessarily steps taken.
Based on your analysis of Mr. O'Keefe's phone and the report that was pointed out to you in cross-examination, and do you have information or opinion where Mr. O'Keefe's phone was located around 12:21:10 while those steps registered?
Objection, Your Honor. So,
That's beyond the scope of the class.
It was pointed out to you at 12:21:10 there was a registered 80 steps. Is that accurate?
That is correct.
Okay. And then you were also asked about the last healthcare data, the last movements of this phone. And it was pointed out that that began at 12:31:56 for 20 seconds.
That's correct. Per the data in the database.
And is that the last movement of Mr. O'Keefe's phone that evening before 6:04 that you saw when you analyzed the entire data in the phone?
May I have one moment to review?
Yes.
That appears to be the last before the 6 a.m. hour.
So that 20 seconds, if it began at 12:31:56, what was the last movement in seconds in time at that time of Mr. O'Keefe's phone?
I'm sorry, can you repeat?
Yes, if that was a 20-second interval at 12:31:56, what was the last second that evening that Mr. O'Keefe's phone moved?
12:32:16.
And then when you analyzed the phone and were asked about these times, is there any movement between that last movement and 6:04:01?
Between the 12:32?
Yes, 12:32:16 and 6:04:01. Any movement of that phone whatsoever?
I do not have anything supporting that in my report.
Do you know what was going on with Mr. O'Keefe's phone at 6:04:01 a.m. on the morning of January 29, 2022?
I do not know precisely what was happening with his phone at that at that time in terms of movement, if that's, or are you asking me, I'm sorry, can you clarify what you mean
Yes.
by the question?
The next movement after 12:32
Is the
16
6:04.
is 6:04:01
Correct.
a.m.
Correct.
Do you have any information about where or why there was movement of the phone at that time?
I don't, that wouldn't be inside my digital evidence, I don't believe.
And the last question is, the next movement at 6:15:14, do you know if that phone was being moved by somebody or somebody else than Mr.
The
O'Keefe?
phone was in motion. I do not know if it could be by a person, it could be on a rail car. I don't think it was on a rail car for clarity, but I don't know what is causing that motion at that time.
Thank you very much.
Any follow-up, Mr.
Yes, please, Your Honor.
We have a moment, Your Honor.
Excuse me. Go ahead.
I know.
Thank you.
Ms. Hyde, you were asked questions by Mr. Brennan just moments ago about Celebrite and release notes. Do you recall those questions?
Yes.
And did Celebrite, beyond stating that their opinion was the 2:20:40 a.m. timestamp was not reliable, did they give any reason at all for why they concluded it was not reliable in that? I'm sorry, we'll wait for the,
Thank you, I appreciate it.
and I'll repeat the question.
Thank you.
May I, Your Honor? Thank you. In that release note, does Celebrite state any reason for why they wrote not a reliable timestamp?
There are other
I'm sorry, my
published, but
question
not
is, do they
Celebrite?
state in the release note whether there's a reason for why they concluded?
Thank you, ma'am. Thank you, Your Honor.
Please try not to talk.
I will,
Sorry, Your Honor.
Thank you.
2.
Not asking you to read it, just asking whether or not they give any reason for the conclusion, not a reliable timestamp.
One moment, I'd like to review what they wrote. Thank you.
Absolutely. You're welcome.
Yes, they do. They state that further research since is the reason that they're doing it, that there's further research.
Did they state what that research is?
They don't, but
All right, but they don't state what the further research is.
that is correct. They
All right,
state
now
that
what I'd like
it's
to do is
unreliable.
move on to Axiom.
Mm-hmm.
You were asked questions by Attorney Brennan, and you referred to Axiom as using a different parlance with the timestamp of carved, correct?
Celebrite uses this deleted demarcation or recovered demarcation. Axiom does not do that at all. They speak to how they recovered the artifact, be it that it was parsed. When I say parsed, I mean the item was where it was expected to be in the algorithm, found it, located it, and said it's here, versus carved, which is when they have to go into an unexpected area, such as slack space, which would be the areas that are not yet used or were previously used to extract the data from that.
So Axiom actually recovers the timestamp, but Celebrite does not. Is that correct? Is that correct?
Yes,
Okay.
currently, previously, when we did the first case.
Right, but
it's the
currently,
opposite.
Celebrate
Correct.
doesn't, but Axiom does. Axiom recovers 2:27:40 a.m., correct? Timestamp? They
That
recover-
is the timestamp that they show for that artifact. Correct.
Exactly. So now I'd like to go back to the next topic, our discussion about Mr. O'Keefe's phone and secured or not. You talked about one example of maybe needing to use a biometric to unlock a phone. And that might be a reason, as I understand it, as to why someone might not put it in a Faraday bag or box. Do I have that correct?
Correct.
Okay, do you know whether the passcode was immediately provided on the phone of Mr. O'Keefe?
I do not have that information.
Assume that the passcode was immediately provided for the phone of Mr. O'Keefe. Can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay. And that phone was obviously not put in airplane mode, Faraday box, or Faraday bag after 6:04 a.m. on January 29, 2022, correct?
Correct.
Now let's go to,
Well, I don't know if at some point past 12 o'clock. My report only goes to noon, so just for clarity, I don't know
Fair enough.
anything past noon.
fair enough, but from 6:04 a.m. until approximately noon on January 29, 2022, at least that time, that phone is not in airplane mode in a Faraday bag or a Faraday box, correct?
It would appear such. Because I didn't analyze past that, I don't know if it had been potentially Faradayed and then it broke Faraday and got data, but I don't suspect that based on this. It appears that that data was live. But I just have to speak to the fact that I just don't know because I didn't go past noon.
Right, but you're going past noon.
Right.
I'm not.
Okay.
My
yeah.
question,
6
and
a.m. to
I'm-
noon, it does not appear to be Faraday.
So to be clear, from 6:04 a.m. on January 29, 2022, until at least noon of January 29, 2022, the iPhone of Mr. O'Keefe is not in airplane mode, it's not in a Faraday bag, and it's not a Faraday box, correct?
Unless it was in a broken Faraday bag, like they put it and it was failing. But it does not appear to have been placed in Faraday bag.
All right.
Well, I'm just being honest. You should test your Faraday bags. They go bad. I use Dr. Katz's testing methodology, but in 100%, it appears to have been receiving signal for that entire period and not in a Faraday bag, which would be best practice unless biometrics were needed.
So let's now go to hopefully what are the last two categories of questions. With regard to the iPhone of Jen McCabe, do you have any knowledge as to whether over 200 calls were auto-deleted on her phone? You analyzed it.
We can see that calls were auto-deleted. You're asking me if the number of, I just want to make sure I understand the question. If the number of calls that were auto-deleted, if that exceeded 200?
My question is, do you know whether there was auto-deletions on Jen McCabe's phone? Do you know that?
I'm uncomfortable with the term auto-deletions because I don't know what that is inferring.
Okay. Did you analyze her phone at all for deletions?
I analyzed her phone to see if there had been deletions of call logs. And what I found was that there were records that were removed by the system and not recoverable from that database, but were recoverable from biomes.
Understood. Now, what I'd like to do is to address your answer in response to Mr. Brennan's questions, where you said that the issue with regard to Mr. O'Keefe's, or just generally your proposition, that there was no impact on your conclusion because more data had been obtained. Did I get that correct?
I believe my statement was there was no impact on my conclusion with the fact that it had not been in a Faraday.
Right. So isn't it, though, the case that when a phone's not in a Faraday and is therefore active, data can be overwritten?
Yes.
So if data can be overwritten when it's not in a Faraday, you can lose that data, correct?
Is there data that we're concerned? Yes, theoretically.
Right.
Yes.
You talked about, in response to Attorney Brennan, the 12/31/56 steps, and you said the last, according to you, last movement 12/32/16. Do you recall those questions?
I recall the questions.
Yep. To boil it down, isn't correct that that phone was moving at that time?
May I check the timestamp again? I
Absolutely.
apologize. There's
Oh, no.
a lot of timestamps going back and
Please
forth.
do.
12/31/56, is that
Yeah, that's the start. Yep.
Oh, yes, this one there definitely is. Yes.
So, doesn't matter what kind of movement, but that phone was moving starting at 12/31/56 and still moving until 12/32/16 a.m. on January 29, 2022, correct?
Yes.
Thank you. Appreciate again you answering my questions.
Thank you.
All right, Ms. Hyde, you're all set.
Thank you, Your Honor.
All right, see counsel about scheduling. Jurors, feel free to stand up and stretch.
Oh, that's exhausting.
Yeah. Yeah, that's like a version of hell.
Yeah, dude. Listening to Jessica Hyde, I clearly need to read more books. Listening to Alessi, I need to have a nap. That's brutal.
At some point, she was essentially conducting her own cross-examination because he couldn't ask the questions. He did not understand what he was saying, and she had to clarify and then sort of frame the questions for him. That was painful to watch.
It was.
Yeah, that was the worst.
I bet they got early today.
Oh, yeah?
Are they getting out?
Oh, I was just assuming because it's 3:30.
May I?
Yes.
William Reed.
I would like to play clip
Yes,
15,
clip.
please.
All right.
Excellent.
Clip. Yes. Finally, we need some entertainment.
That's right. We need some clips. Let's go.
That was torture.
Totally was Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
She is such an idiot.
That's not crazy at all, hey? No.
So, folks, I talked to the lawyers briefly about scheduling at Sidebar, and I'm told we're actually ahead of schedule. So with that, rather than beginning a witness who's probably going to take a while, I may as well let you go and enjoy the rest of this meeting. So we're on schedule, ahead of schedule. We'll reevaluate that tomorrow. Now, you will see lawyers at Sidebar asking for as well. So same cautions, please. Do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And be very careful with your session. We'll see you tomorrow. Thank you.
All right, to the court, please. Close and open, follow me.
Damn.
Would you come on up?
I love that clip.
Yeah. It's insane.
This is a game.
And I mean, like, you're going to try to put Jen McCabe in that light, too. Like, oh, it's me or you, like some kind of blood sport. She answered your phone and helped you. Like, you're going to convince people that Jen McCabe's, so even someone to have a fight with over what? helping you? That's insane.
And not
Totally
even a friend, by the way. Not even
Yeah.
an acquaintance. You know, that's who you're going to pick, her and Carrie, when you're in your moment of distress after your boyfriend doesn't come home from a party.
Mm-hmm. Yeah, people that helped you that really didn't have any other reason to, other than they were probably themselves, concerned. Where's John? I'll help look for him. But yeah, these are the people she's gonna drag through the mud for years. It's either me or you. Yeah, I think out of the two there, Karen, I think it's gonna be you that is going down. That's so stupid to say too. Like, what is this?
There's like another
Come
clip
out
too
for a
where
bad
she's
wrestling
like,
match.
she's like straightening her hair, and she's like, we don't want to put too much emphasis on the how's long did night gold.
Yes. Yeah.
That would
too.
Yeah, we put the whole thing where she's like, she's like, I don't want to put too much emphasis on it because then they're going to think it's either me or Jen, and that's not what we're here for. Like, lady,
right. Yeah,
pick one story, stick with it.
It's so cartoony.
That's actually when she was curling her hair and gave us a whole dissertation about when she needs to curl, depending on the weather, what the weather does to her hair. And then, oh, by the way, the tidbits about the case.
Right. Yeah, as an afterthought.
She's psycho. She reminds me of Laurie Vallow. How Laurie Vallow was like obsessed with like what she was cooking that night when she murdered her kids. It's like I'm like, what the fuck? Or she had but Karen's like, oh, I always had to have my sleeves tailored because my mom would never allow that. It's so important to look good in court.
Yeah. I don't want them thinking I have the sleeves of a murderer. But like this me versus you thing, that is so, it's so cartoony though. Like it's a bad wrestling promo, Oh yeah, Jen, me versus you, yeah. Like it's ridiculous. It's theatrics. She thinks that's going to keep her out of jail. Good luck. Good luck.
I don't know why they didn't play that right after Jen's though. I have to say this was a little random of when they played it. I think they were trying to wake everybody up after all of that, perhaps.
Yeah, I could see that.
He should have had a couple though. Like I want to hear. They need to trash Karen pretty good before Proctor gets on. Like we need to hear some of her texts where she's talking about the mother and Paul O'Keefe. I mean, if they could get those in, I don't know if they could, but
I wonder if there's any we haven't seen where she is trashing Proctor, that never made it, that none of us have ever seen. I bet you anything, the ID Discovery producer, she was so sharp and she knows this case so well. Surely she asked him or her about Proctor. I wonder if there's some goodies we're going to see. In other words, where she slings it back.
Mm-hmm. Yeah.
I mean, I know she talks shit about the nephew. She says that she wanted to scream in his face or something. He's a lying little shit.
Oh,
right.
So that'll be a good one to play. Right? If I don't know if the nephew's going to testify this time though.
I think just the niece, but
yeah, I don't think he is this time. I don't think it's necessary.
I hope not. I mean, I think they've gone through enough. Yeah, I would hope he doesn't have to.
But I think
last time when they testified, it was their choice. To be fair,
I'm not saying they're being drug into it, but I mean, like, I think they've all got to be exhausted, and they're young. Like, they can cut them a break. Please do.
I mean, I feel like if I was young, I would want to be involved and I would want to say my truth. And that's kind of what it sounded like the niece felt. Like,
yes,
he was the one that was woken up in the morning and she wanted to be heard and she wanted to be treated like an adult. And I get that. Like, I feel like I would feel the same way.
Yes, I heard the same thing. And of course, the FKR people were trying to, frame it like, oh, they're using the children and it's terrible. They've got them brainwashed, I think was the narrative. And I heard the exact same thing, that she was just chomping at the bit to get up there and testify. But again, I mean, I understand that. I just wish they didn't have to.
Why are they all still sitting there? Oh, they're at Sidebar right now.
Another Sidebar.
I want them to call William Reed, please.
Yeah, right. Yeah. Release the
really want that.
hounds. Oh God.
Yeah, they could play his clip. His
Yeah.
Well, she said she hit something.
Hit something. Yep. She said
Which is
that.
the first thing that would be on your mind when your boyfriend's dying in the hospital, right? Dad, I
Right.
hit something. I
Uh-huh.
bumped a car going 1 mile an hour. I did a love tap
Right.
to his car. Oh, and by the way, he's dying in the hospital. Like, it doesn't make any sense.
Yeah, priorities, right? Like, I know, it's a tell. That's the thing with these crazy people is they don't understand that their bizarre behavior is a tell to people who aren't as batshit as they are. You know what I mean? It's like you're tipping your hat, crazy pants. Like, come on. But no, they don't think about it at all. Oh, that's just the way you are. Like everything we do is what innocent people do. Bullshit. No.
She must have said this to her father in front of someone else. Because I can't fathom why they would volunteer this information on television otherwise.
I
Try to
agree.
get in front of it. Yeah.
I thought it was someone in the hospital, like, that was going to testify, and like he was trying to like curb it. You know what I mean? Like by going on TV, but no one testified that was in the hospital. So no idea.
Oh, some of this
Oopsie
chat
doodles,
is
Burnsy.
so funny. Bill McIntyre, no one puts baby in the corner. He's so clever. Love, another person in the chat just writes, is she nuts? I'm being serious. That's
Yeah, no, she is most definitely nuts. I believe her to be completely insane.
I just don't understand, like, why we have not heard about Karen's phone extraction at all, even in the last trial. Everything was from John's phone or Jen's phone. Like, we didn't hear. Did Karen delete all these voicemails? Did Karen delete everything? Like, we don't even know. And like, why not? It's like they're able to like file a motion to hide it or something.
Did she not leave the police waiting outside when they went to
right.
get her
That was
phone?
the second, but I don't think that would be in this trial. That was more for the witness intimidation. But the first one, she turned over, and allegedly Proctor was looking for nudes. But like, we've never heard if that phone extraction had that. Like, they talked a little bit about it. I think it was Tully that was like, we did see some deletions, but like it was an objection, and then we never heard any more about it. So like, what's the deal with that? Like, how are you able to go through everyone's text messages for the past 5 years and trash them, and we don't even see her phone log at all?
Right,
like her messages and stuff, besides what went to these people?
Or the health app data, as Kevin says there. Yeah.
Oh yeah, health app data on her phone.
Good point.
So who's going to even be doing that? Because Garino's done. The 2 phone experts are done. So who would be even presenting that?
I don't know.
Thank you. I'll see you tomorrow morning. Do you have to sign my signature?
I'm very concerned about her phone data.
I know. I would.
I really am.
There's got to be something there, I would think.
Yeah, there
Well,
has to be.
Too bad we're not getting Daddy's phone data. That was
Right.
and was denied because I want to see if she left a voicemail that night. Right? We know she called him. Was there any voicemail on there? We can't know that, but from his phone.
Yeah, I have no idea like how we're gonna even see what's on her phone, unless it's gonna be Tully again. I guess Tully was the one that talked about it last, but very briefly. He didn't go into the details. But
I'm
that's
just
weird.
looking at the poll as we end court for the day. We have 1,001 votes today, which is, I think, more votes than usual by a bit. If you haven't voted, go ahead. But as of right now, 63% of you are leaning towards guilty second-degree murder, 24% OUI manslaughter, and 12% not guilty.
Where is that poll? Is that on your?
It's on Yellow Jails.
I just wondered because every time I put up a poll, it's so lopsided because every troll in the universe comes in and makes it lopsided for FKR. It's just my polls mean nothing anymore on this case. Like all of a sudden, people with 0 are in the comments. Obviously, we can't see who's voting, but it's unbelievable. I actually saw something on Facebook where somebody reached out on Facebook to the group and said, get your Twitter and go on Coffin Daffer and pick, the proper thing. I'm like, oh my God, how can I make my polls mean anything at this point?
Yeah, it seems to be pretty diverse. So, I mean, obviously a lot of different opinions watching, which I really do appreciate.
Of course.
But
Yeah.
the majority is still leaning towards second-degree murder. Like, I see it. I just don't think that's where the jury's going to land, if I'm being honest. Maybe I'm being a little pessimistic too, but
I definitely don't see an acquittal. That's for sure.
Her clips just like tip the scale so far against
dude,
her.
Yeah.
Because
Yeah.
then you see her demeanor and the way that she doesn't care about John O'Keefe at all, and or anybody really, and the way that she's treating this as a game. Like, I just feel like that's gonna really turn them off and make them think she's a psycho.
Did you see her today scrolling through her phone during testimony?
No.
Yes,
Henry?
I post this picture. Yes, Karen. She's, who caught it was Grant Smith. He caught it and posted a picture, and I need to take that picture and repost it and just say, come on. I'm going to find a picture of somebody else who I bet you anything there's other murder defendants who have done that. So I just want to see what other brain value would do that as a murder defendant.
See if it's,
it's
a common theme amongst.
Kids can't even be on their phones. I thought you were supposed to have your phone put away.
Remember on one of her interviews, she was like, I Google my name every day to see what the news stories are. Like, she's obsessed with this.
Yeah.
Yes. I mean,
she loves it.
You saw the ID documentary, right? Where they were talking about how Karen was always a little performer and all this. That's when it really clicked for me that she's very much loving this. Is that I think she fancies herself as a performer, that, she went into the business sector, but maybe she could have made it, you know what I mean? And this is her first and only connection with the kind of attention she's always wanted. And that's why she's leaning into it, because she's enjoying this. This is her 15 minutes 30 now. And she's hanging on. She's loving it. Absolutely.
The fact that her and Turtle Boy were both teachers tells you everything you need to know about this country.
Yeah.
It's not a good sign. Yeah.
Not at all. We're prioritizing the wrong things, apparently.
Yeah.
Oh, I'm telling you, every week I feature some beautiful female teacher who's been having sex with a 12-year-old.
That's so weird.
Yeah, why is that a new trend, or is it we're just learning about it now? Was this always the thing?
I hope not.
Right. Always the thing. I think we're just hearing about it more, and I think a lot of cases reported.
I just don't understand how they're even attracted, because little kids smell. You know what I mean?
That's a good place to start.
There's nothing adult or sexy about them.
No.
No. I have the kids in my family, I'm they're the grossest things. Their noses run all the time. I don't know. Right. It's just it's so gross. It really is so gross. I don't even understand what's going on in these people's heads. It's wild.
It is. It's shocking. And they're always married with children of their own, in their 30s and beautiful. And yeah. So back to the whole teaching thing. It's can be a mess. Obviously those are the exceptions, not the rules. But in this case, we have two.
God damn.
Well, tomorrow we start with new testimony. No idea who it is. They're not really announcing the witness order here. It's been interesting too. I feel like this case is just moving a lot faster than the first case in chief. So I don't know who they'll have tomorrow, but
And at
I
this
gotta-
rate with the clips, I'm hoping when they get to Proctor's text that half the jury starts going, hell yeah, like they're not going to have a great.
I suspect that the defense is going to end up being the ones to call Proctor, if I'm being honest.
Yeah, I would assume so. And I mean,
You think
but
so? I do. I think that
if any side called, yeah, I would think defense.
yeah, because they don't really need him for the case in chief, and it's probably best to cross him than put him through a blistering cross with the defense. They'd have to call him on direct. So
right.
Well, obviously, we know they did that last year, right? They called him and tried to get ahead of it. But I'm kind of leaning toward you in a way, thinking, why in the world do they really need to do this? This is flowing so smoothly. Everything's coming in chronologically. Kind of to throw him in might just kind of really mess up their flow.
Yeah.
I mean, I
They're
just
trying to keep it streamlined for sure.
I hope they call him and he's just like, they're like, did you call her a whack job? And he's like, she is. Look at her.
right.
Yeah,
Look at her.
exactly. Have you guys seen the clips? Look at her. Yeah. Big time.
I mean, what else are you gonna do? Just own it.
Right. I mean, can you imagine Jackson reading that again? Quote unquote, you say she's fucked? And like half the jury's kind of smirking, like, have you seen the clips, bro? Yeah, she is.
Yeah.
She's insane, man. Yeah. Christ.
Yeah, I think they should have saved the clips of the voicemails till after Proctor was on. Just let him talk about that and then, play.
But I mean, it's under the skin now, though, right? Like they're steadily absorbing more and more examples, especially through these clips, of her being completely insane, unhinged, weird, venomous, bizarre. And then when you finally get to Proctor, it's going to be like, yeah, I mean, last time they were all aghast, like, holy hell, this is brutal. But now they're kind of front loaded with all these examples that I can't imagine the reaction's not going to be the same. I don't think.
Yeah.
So. I mean, there'll still be outrage, but to the degree, probably not.
Yeah, I mean, I think bury it in the middle, and like I think put Proctor on before Higgins, because then, you get Proctor out of the way, but then you see what she was doing with Higgins, and it's like, okay, she has a whack job. Like,
yeah.
I mean, that kind of
Whack
almost cancels it out in a way, because she was sending all kinds of crazy messages to him.
Yeah,
right.
She's a whack. She's a wackadoo.
I feel like you're from my neighborhood.
I think they have to call still, though. They have to call Brian Albert. They have to call him, and they have to call Higgins, I think. I don't think they have to call Proctor. I agree with that. I've always said that because you're the case agent. You're not doing the collection. You're basically sort of quarterbacking the flow in a sense, but more like a coach, seeing what everybody's doing.
Mm-hmm.
I think I might. Would you guys hold him? Would you guys hold him off and just not put him on? Proctor meaning?
I might. I don't think I think I would probably prefer to cross him and be able to ask leading questions and give direct to the defense. Yeah, he's not important. He's not that he's not necessary. He's going to be a black eye. Better let them, get him on direct, and then you can rehabilitate him from there. I mean, I might not even want to call Brian Albert, to be honest, though.
Why?
I mean, what does he really add?
Well, I think what he adds is why he didn't come out of the house. I mean, that he just didn't hear. I mean, we've gone over that ad nauseum with even our own personal examples about unless you're looking out your door, particularly if there's no sirens, you've been drinking all night. It's, you've been asleep for a few hours. You're not going to wake up. You're not going to have any idea anything's going on.
You can get that. You can get that and lead him if you let them call.
What if they don't call, and then it leaves the jury wondering, gosh, I wonder why they didn't call him. I think that that's just a witness. You would just sit back at this point and say, why didn't they call the owner of the house?
Yeah, I mean, I think that you have to call him, and Higgins.
I think you have to call Higgins too. And they didn't testify well.
I thought Higgins was pretty good. I mean, and then, it was like him using that tool. And then Brian Albert, I think, was good, except for like the phone thing. He was a little bit squirrely about, but like pretty much they both came off as like not what Turtle Boy was making them out to be at all. So I feel like the jury's going to be like, okay, they're just cops. Like, you know, like what?
And sort of kind of pivot, but like I've been hearing too, like has anybody seen Meow, the blogger? Has anybody seen him? Is he's been screaming about people showing up, and again, there's no sign.
Oh, he didn't show up again today?
I don't think so. I don't think so. But given, and I'm surmising, but given how Alessi was behaving today, I don't know. Somebody might have, been sharing key bumps and Addy pills. Just saying.
That is.
I'm just surmising. I'm wondering, right?
Horrible slanders to place.
Wow, I'm all wondering, right? I'm just asking questions. Right?
You're asking for a duel.
I think he was outside the courthouse because I saw like some video where he's like, they just start mowing the lawn when we're watching the trial, like flipping out because they were like mowing the lawn outside or wherever they were. And he was saying it was conspiracy.
Really? Are you serious?
Well, he was insinuating that they were doing it on purpose, but I'm like, yeah, I'm sure.
Oh my God.
Of course, the lawnmowers, the science.
Yeah. They're all in on it. Yeah, yeah.
Hey, everybody keeps asking, and I haven't seen. Have you seen whether ARCA got their report in?
I'm looking at it, but I don't see it.
Probably the end of the day.
Well, they have till 5, so they've got about another hour.
Even if it's late, she's going to allow it. So
yeah, even if it's Friday, it's probably coming. I mean,
even if it's next week, she'll still allow it.
Well, I hope not, but it's possible. Boomer, you got a shout out.
What's happening?
It's like Aiden's Deke nose.
Oh, geez.
Meow. No, well, that's who sent it. But I saw where he said he did not receive a journalist spot for, what did they say, 10 days maybe? Something like that.
Oh, yeah, they're doing that lottery. I don't know. So I don't see anything on the docket about ARCA right now. It does look like they need a petition of materiality for an out-of-state witness. It looks like it's the keeper of records for Ring.
I wonder if Ring actually we have any more information than last time. I'm not expecting much, but
Well, judging from this filing, it would seem that they're anticipating that they're going to authenticate video as well as explain how recordings associated with the subscriber's account are maintained and could be accessed by users through the subscriber's account. So it sounds to me like they might be tackling the deletion.
Yeah, I mean, at least
would be great.
they could
That would
show,
be great.
even if it's possible. I mean, I don't think that anybody else deleted everything except for her alibi video. Like, come on.
Well, this is the Commonwealth, so I'm assuming. I think there's been long the assumption that she deleted, this footage, and I think they're probably going to be able to get it in a little bit better now because they're trying to bring somebody straight from Ring.
Yeah, I mean, that's good.
Yeah, that's interesting.
I gotta drop, but I will see you guys tomorrow.
See you tomorrow. I was just going to say, does anyone else have anything else to say, or can we wrap it up?
No, I'm good. I'm good.
All right.
Thanks so much.
All right, guys.
All right.
We'll be back again tomorrow. Keep Kevin in
Have
your
a good
prayers. All right. Bye.